Hey, what's up, everyone? As Rachel's phone goes off right when it starts. Can you put that thing on mute?
I'm sorry.
Or vibrate?
Yes.
Yes.
Done.
Wait, is mine? Yes, it is. Okay.
It was your story popping up that made it beep.
Oh,
just so you know.
Wait, you get notified on people's Instagram stories?
Yeah.
Or just my Instagram stories?
Just your Instagram stories. I could care less about anybody else's Instagram
I don't even know how to. I don't even think I know how to notify myself. I don't have that set to mine because I don't care whose Instagram stories go live.
I don't know why it popped up.
All right. So welcome in, people. I have the feed from the ABC affiliate in Utah, ABC4 in Utah. And I'm looking at it like off screen, and I'll see when they pop up the feed. And there's activity going on in the court. We're just going to pull it up and watch it. Right now, this is all we are seeing. Taylor Frankie Paul in court, 4:30. They're just wait. So when I see something happen and they show a live feed of the court, we'll do that. So a couple things that I want to say right off the bat. Number one, anybody that's familiar with the Laura Owens case, just know that Rachel and I have a track record of when we go live, something happens in the Laura Owens case. One time, as we were recording, we found out there were 7 new felony charges against her. And we can't figure out what the other time was, but something happened. God, what was it?
I wish I could remember. It wasn't, I don't think it was something like, oh my gosh, she's being criminally indicted. I think it was something less significant, but it was like news. I wish I could remember.
Yeah, it was something along those lines. So just know, and by the way, today is plea day in the Laura Owens criminal.
Yes, which we just talked about. I think it's being overhyped.
Yeah.
But certainly the fact that we're live would tend to suggest there's a chance that we will get some news. And the news would be that she's accepted the plea. There's no other news to be had.
Yeah.
But I think that it's being overhyped.
We have a reporter behind the scenes that said as of a couple hours ago, no plea had been accepted.
Yeah.
So, all right. So today, they still haven't pulled anything up from the court. Probably be 15 or 20 minutes. But the reason why we wanted to come on a little bit early is because I think a lot of people are confused on what the hell this thing is going to happen today in this hearing for Taylor Frankie Paul. So I thought it was just, hey, we're showing up today and the judge is going to decide. Currently for the last 3 weeks since the April 7th hearing, a judge at that time, I don't even know if today's judge is the same judge from April 7th. I don't even know. But that judge on April 7th said for the 2.5 weeks previous to April 7th, she had lost complete custody of her child.
Right.
And then on April 7th, he said, okay, I'll give you 8 hours a week supervised. So now April 30th comes. He's like, okay, you'll get 8 hours a week until our next hearing on April 30th, where you will both present your cases, and then seemingly a judge will decide on this. But both of these people have filed protective orders against the other, and their custody agreement has not been filed with any court. It's just a written agreement between the two of them. So why don't you just do your thing?
And this is my understanding. I haven't seen the court paperwork, but from Utah lawyers talking about, this publicly, it sounds like the case is that in Utah, if you're going to file for a protective order, and a protective order is similar to like a domestic violence restraining order in California. It is a very serious order that goes on a background check, and it can be enforced with criminal remedies if violated. Okay. It does not mean that you've committed a crime. It doesn't require a criminal conviction in order to issue, and it's not issued by a criminal court. It's done by a family court. But if you violate it, the cops can arrest you on site. You can be charged with a crime if you violate it. So in Utah, if you're asking for a protective order, it has to be a separate case. They call it siloed. They say they silo it from a divorce, or in this case, a paternity case, because they were never married. And so Dakota had filed a paternity case to get a custody order, similar to the Laura Owens case. And there was a paternity case. where custody was at issue, but then they each filed a separate case for requesting a protective order. So those two cases, Taylor filed one, I guess in the other order. Dakota filed one, and then Taylor filed one. Two separate cases, but they're being heard together because it makes sense for judicial economy.
Okay, so when you say the phrase protective order, meaning
Protective order.
Stay away from me. Like, what is the protective order? Just
the protective order would be the equivalent of what we really talk about as restraining orders in California, and I think publicly are more commonly referred to as restraining orders. Yes, it's a protective order. Stay 1,000 feet away from me, stay 100 yards away from me, whatever. Don't harass me or threaten me. Don't communicate with me. And if you do, I call the cops and you go to jail, right? So very serious order. Those have to be separate cases in Utah. They are distinguished from what Utah calls a restraining order, which is an order made within another case, like a paternity case, which just says, hey, you guys can only communicate about the kids. Don't talk about anything else. But it's not a background check type thing. There are no criminal remedies for violating it. It's just like any other order in a family law case. It just happens to say you're restrained from doing something. It's just not nearly as serious. So they're not asking for those. They're asking for protective orders against each other. But what I have seen some speculation about online is, could there be restraining orders issued instead of protective orders? And I'm not sure if the judge even has the power to do that. So we know one thing that is going to happen for sure. The judge is going to take these two protective order requests, again, separate cases by each of them, is going to take evidence on those. And I don't know, I doubt a ruling would be made today. It could be, but consider those today. The question then beyond that is this judge going to make a custody order today? The judge can. There's a temporary order in place, but in Utah, they're not supposed to have protective orders determining custody for lengthy periods of time. So because it's a separate case than the paternity action, there's a question whether the judge procedurally will think that they have the right to make long-term custody orders here. And there's also the issue that in the paternity case, they reached an agreement for custody.
80-20.
But yeah, in August, yeah. But they never made it a court order. So even though they resolved that case, there is no current court order for custody, which means theoretically, if they walk out tomorrow, there's no court order for custody that could be enforced as a court order other than in the protective order case. So if the judge just says, look, I'm not granting protective orders, or I am granting protective orders, not making a custody order could potentially leave these folks without any custody orders, which would be a disaster. That could also be what happens. But because it's such a unique procedural posture in Utah, because of how they handle protective orders separate from cases, like paternity cases, I don't know. And I think at least one of the Utah lawyers.
We have the court.
Doesn't know either.
Let me pull up the court and see what we got. Oh, nobody's in it here.
Empty courtroom.
It looks like the hot bench. It looked like hot bench court.
it looks like our old hot bench court, I think. Oh, there's the JA. There's the judicial assistant or clerk.
Who, this guy or her?
No, the gentleman over there behind the computer. One of those people is probably the judicial assistant or clerk, yes, of the court. Yep.
And then who's the small one that can't even fit over the top of her monitor?
Oh, I don't know. I didn't even see that person.
Yeah.
Is that someone wearing a robe? Is she wearing a robe?
I don't think so.
Okay, because I just see a little black.
This thing is not very loud. Hey, camera guy.
Oh, well.
Oh. Oh, yeah, that's the guy that's probably working the camera. It's not very loud, is it? Well, nobody's talking, so I guess that's why.
I'm sure they have it on mute. They'll do that until they officially call the proceeding to order. Otherwise, it picks up everything in the courtroom.
So let's see what videos this suggests to me on YouTube. Let's see. Live Taylor Frankie Paul. We can watch the Veolia Atlanta Pickleball Championships on Court 26.
I'll pass on that one.
The Buffalo Bills new stadium construction live stream. The Bachelorette rap video from Desiree's season.
Wait, so if I start saying really weird things right now, does that mean that your YouTube feed will like start like can it hear me? Can your YouTube? I don't know technology. You know, I don't.
What do you mean? Can my YouTube feed hear you?
Like, you know that our devices listen to us. Can it? No, you're going through your computer though.
Yeah.
So it's not like your phone is there.
No. This is probably just for videos that I've looked at on, so wrestling stuff. Here's a wrestling one. Kevin Nash comments on the Hulk Hogan 4-part documentary on Netflix right now, which I need to watch.
That is.
You don't know who Hulk Hogan is?
I don't even know what that is. Of course I know who Hulk Hogan is.
Okay. Kevin Nash was a wrestler that wrestled at the time of Hulk Hogan. So he's got a podcast.
Bruce, you're not allowed to ask Steve if he could design any dating show because he's not allowed to disclose the dating show that I've just designed.
Oh, yeah.
Which is really good.
Andrew McCarthy's True or False. Andrew McCarthy went on the Rich Eisen show and played True or False. Here's how to play roulette. Win $1,000 with this easy roulette strategy. I've got some Smallville videos on here because I'm in a current rewatch of Smallville, which I really, really like. I love that show. Anyway, I'll remove this for now. We'll bring it back up when I feel like. Can you hear rumbling of it?
Yeah.
Okay. Mm-hmm. Yeah. So
they clearly have it on, which they don't do here in Los Angeles. They wait to turn it on until they're calling cases because they pick up everything in the courtroom.
And because we're dealing with a legal matter today, I've got
your legal pad.
My legal pad.
I've got
my legal pad has
everywhere.
nothing but a bunch of Bachelor related.
Yeah, my legal pad's here.
Notes on here. Episode 9. God, this is my notes from Grant Ellis's season of The Bachelor.
That's how long it's been since you've used a legal pad?
It's the last Bachelor related show that aired. Well, outside of Bachelor in Paradise, but yeah. It's the last Bachelor or Bachelorette show.
So I haven't watched The Bachelor or Bachelorette in a long time, but as I think I mentioned to you, after all of this, and especially after listening to the Love Trapped podcast, I said I have to go back and watch Clayton's season. I mean, I find The Bachelor not particularly compelling to watch, I'll be honest. But boy, was that rose ceremony crazy.
Well, so you did see the rose ceremony from home.
I did. I ended up eventually, I found a little bit of the stuff with who was the crazy girl? Cheyenne?
No.
It was a name like that.
Yeah. I can picture her face, and she was arguing with Genevieve in Niagara Falls, and
exactly.
She was going to push her over the
No, there was some compelling stuff there where she and the other people were like walking around like just like blatantly lying to each other, and then in confessionals saying like ha ha. That was kind of funny, but then I kind of lost interest, so I went straight to the finale, and whew, boy.
Yeah, Clayton really stepped in it at the end where he tells both women standing in front of him, "I've been intimate with both of you."
I mean,
congratulations on the honesty, but probably not something you want to say.
But it did make a lot more sense. I never really directly connected when he said, I'm the last person to lie about who I've slept with.
Yeah. I knew that was from that line.
I think if you had asked me to connect them, I might have been able to, but I hadn't made that connection in my head until I saw that. And I said, oh God, Shrimpgate. Yes, I just watched Shrimpgate. That was actually hilarious, right? I brought you shrimp and you didn't want it. And then there's this whole fight about whether she was in the jacuzzi or not. And it's like, this is literally like, it showed me how much the series has obviously changed since I watched it. Yeah. Back when I read your spoilers in like 2011 or whatever it was, 12. Yeah. So.
What else was I going to throw in here? So once it starts, it's just going to be. I'm not going to be talking much over it, but I told you, so no, I want you to if you think a good point was made or You want to explain something?
Yeah.
I think that most of us are watching aren't going to maybe understand everything. But
I will.
once it starts, we're just going to watch along with all of you. We're not going to talk too much over the trial itself. But because we don't know, like I asked Rachel, are Dakota and Taylor going to be at this? Do they have to be at this? And I don't know, right?
Yes, they have to. There's got to be questioning of them. There's absolutely no way I can imagine that you could have a protective order hearing where one side didn't cross-examine the other party. As I mentioned to you,
Gingras didn't cross-examine Clayton.
Well, there you go. Exactly.
But remember, he said, you know what? He wasn't really pertinent to my case.
Right. He didn't really have anything to do with why we were here. Yeah. Which actually, by the way, is completely true. He did not do anything like that had to do with them being there. But
yeah, by the way, her name was Shanae. That's right. Thank you,
Shanae. Yeah. Shanae. As I mentioned, in California, the parties often don't do direct examination live in front of a judge for restraining order hearings. They submit on the papers, but then the other side gets a chance to cross-examine you. So the witnesses have to be there. It is extraordinarily difficult to do witness examinations like this over Zoom. So I would be surprised if they're just over Zoom.
Yeah. Well, I was going to say, somebody brought up in the comments, is Bruce FaceTiming in from a hot tub? Because I mentioned the last time I spoke, when I went on with Bacon Bears, I talked about my phone call with David Dringus the last time I spoke to him, which was in November of 2025, and he happened to be shirtless in his hot tub.
Wasn't that the same one where he said,
yeah,
140 times?
Yeah, where he called you every name in the book. I went back and looked. I actually don't have the video anymore. I just have the audio of it. I don't even have. So even if I wanted to share it one day because David Gingras attacked me and said I said something, I'd be like, no, I didn't. Here's the proof. I don't have
That's
the
really
video
funny.
of it. So unfortunately, everybody, we're not going to see David Gingras.
That's hilarious.
Shirtless. But
that's hilarious.
I do have the audio of it still.
I'll
never delete those.
Yeah. Someone had said last court hearing they were on Zoom with their cameras off. Yeah. And that makes complete sense because the last court hearing was lawyers doing oral arguments about legal issues. Here, this is an evidentiary hearing, which means the court's going to take evidence. And the big witnesses here are Taylor and Dakota. So you would expect most of the evidence to be from the two of them. Oh,
here we go, I think. Oh, crap. Sorry. Oops. Hang on.
It's like, I don't hear anything.
Add to stage. Yeah.
I don't think anything's happening, though.
Can anybody hear this? That's the problem. It's so low.
I know. I can hear. It's very quiet.
I can't believe this is going to be the live feed of it. Just
wait, but can you not hear it either, Steve?
I can hear very faint in the background.
Okay, so it's not like it's just us because we're trying to listen to your YouTube.
Yeah.
Do you want to try another live feed like East Idaho News? Do you want me to see if I can post something up?
But he might because I don't think it started because the camera would be on the judge saying stuff.
One would assume so. My guess is that this is the JA or the clerk talking in the background about procedural stuff is my guess.
Yeah. It's a little bit louder, but not a lot. Okay, yeah, I think that was just, I don't know if the lawyers, yeah, I can't imagine that the whole hearing today is just going to be us.
We don't know if they're sharing an audio feed.
Yeah.
Or at least I don't know. So I'm just, okay. Oh my God, I'm having to listen to all these ads.
Move. I'll add it back on once I see that camera has moved away from the judicial symbol.
There's no sound on the East Idaho News one either, so it's fine. Okay.
I just heard court is now in session.
Yeah, well, but all sorts of crap happens between court is now in session and calling the first case, right? Sometimes they talk about all sorts of things like, oh, are the parties here? Are there this and that? You know.
Yeah. Until I see that right now the camera is still on the judicial symbol. So until I see that move.
Yeah, I agree.
What else? Oh, yeah. If you want to be involved and you want to ask any questions and you want to participate in the super chat, obviously I will pull those up. Any super chats you want, I will obviously move.
Okay,
those
so now on East Idaho News, I can hear very loud rumbling.
Send me the link to East Idaho News. Well, wait.
The matter of Dakota Mortensen and Taylor Frankie Paul.
It's a little bit louder.
Number 264901444, and the matter of Taylor Frankie Paul and Dakota Mortensen, case number 264901819. Council appearances, please.
Brent Hall on behalf of Dakota Mortensen, who was present, both petitioner and respondent.
Okay.
Good afternoon, Your Honor. Eric Sweenard and Brian Ficklin for Taylor Frankie Paul, who's present with us as well.
Okay, so they're both present.
Well, yes. We'll have one attorney each making oral argument. Is that right?
Yes, Your Honor.
All right, very good.
You can hear Rachel?
All right, so
Yeah.
at the last hearing, I had expressed some hope that there might be some resolution to these matters. Were there any efforts made in that regard?
I don't know if I'd call it efforts fully, Your Honor, but I mean, we've definitely contemplated where we're at, and we've had some good discussions about the current parenting schedules. So.
Okay, any resolution on anything?
I don't believe so, Your Honor.
All right, well, the first matter was the one that was filed by Dakota, so we'll go ahead and hear from you, Mr. Hall, first.
Thank you.
He said oral argument, which does not mean evidence or testimony, which is interesting.
Right. Record's good? Good. Well, Your Honor, today we have two competing protective orders, one from Mr. Mortensen and one from Ms. Paul. I'll start by handling our protective order first, and then I'll also respond to theirs to hopefully save time and judicial efficiency.
We'll give rebuttal to both parties.
Thank you. I appreciate that, Your Honor. I was going to ask. So first off, let's go ahead and start with the protective order. All right. So Mr. Mortensen filed his protective order. As you know, Your Honor, in the state of Utah, we have a few definitions for how a protective order should enter. We have to have a finding by preponderance of the evidence of either abuse or domestic violence that has been committed. Also, I will cite Patoli versus Marksbury, which is the case that indicates that the fear component is a component, but it's not required. It's an either or, as the court's well aware. In this case, actually, it's, I believe, rather simple, Your Honor. As the guardian ad litem has previously filed, we have an aggravated assault charge and plea of guilty by Ms. Paul against my client. That's domestic violence as specified exactly by the code, as it's one of the underlying sections. Aggravated assault under 765103 is domestic violence.
This is the 2023 incident.
This is the 2023 incident. And I would need at this point to cite the statute, Your Honor, which is 78B-7-608, that the court cannot deny a protective order solely based on a lapse of time.
Yes.
That being said, we've provided other evidence as well, Your Honor, of this cycle continuing. If you turn to our exhibits, we've presented at this point 9 exhibits, of one being the actual incident and others being additional incidents that have occurred since the 2023. I did have one rebuttal exhibit, but I'll get to that later, of a little previous to 2023, the February incident, but I don't need to address that now. As you can see, Exhibit 1 is the actual recording of that incident that resulted in the charges. Then we have Exhibit 2, which is an incident that occurred, and the video we provided shows Ms. Paul striking Ms.
I viewed them both. I viewed them.
You viewed them all. I just wanted to run them through for the sake of the record. And then Exhibit 3, of course, was a picture of abrasions on an assault that he claimed occurred on that day, and he would testify to the same at proffer. One thing I wanted to point out about that, Your Honor, is that was August 3rd, 2023. That was the day she pled guilty to the assault under a plea in abeyance. So I think that's interesting that we still had an incident that night. Exhibit 4 Again, more scratches of a separate incident, Exhibit 5. Again, and this is an audio recording because my client's recording device was in his pocket, not showing. It does show at least a strike of some sort on the door, which is a form of domestic violence if it breaks, but also you can hear kind of the anger in what we have there. Exhibit 6, we have an audio and video recording of, again, another assault that happened on October 15th, 2024. Exhibit 7, we have an injury that occurred. You can see the injury is noted. We had to fix, I believe. This one's 2023. Exhibit 8, we have another video and audio recording of the May 27th incident. So this is the one that we've been kind of back and forth with the pleadings, as you can tell. I'll get into that a little more when I respond to that, since that seems to be the main issue that Ms. Paul has in terms of alleging violence with him. Then we have the October 16th, 2025 incident that we also recorded. Oh, this is the one where he had his phone in his pocket. And then we also presented, of course, Exhibit 11, which unfortunately there was no recordings of the most recent incident. We're going to call it the February 22nd to 23rd incident because there's actually 2 events that happened, both separate on those times. This is the most recent, 2026.
Are the pictures that she provided for bruising from a different date?
Yes, my understanding is that was from the May 2025 incident.
Okay.
That's the one that I think is the greatest dispute.
Okay.
So
Yeah, 9
from
different
that,
incidents.
I did want to show you Exhibit 11, Your Honor. I know you've listened to it, but that's the recording of a phone call that occurred between Ms. Paul and Mr. Mortensen about a day or 2 after the most recent incident in February.
Is this the one where it was represented she was screaming on the phone? Is this...
There was some screaming, yes, but what was really important was the statements that were made by Ms. Paul during that.
Okay.
For example, at the second, just to help the court when you're looking at it, on timestamp number 2, my client asked, well, why did you attack me? And number second 8, Ms. Paul responds, I already told them that. And them, if you listen to the context, was CPS at the time, Child Protective Services. I already told them that, yes. Or yeah, was actually the appropriate quote. But here's where I wanted to really get into. And that was later on, about a minute later in the call, he says, well, I've got to tell the truth. And the response was that it will ruin your life, is what she told him. And then at 1 minute and 52 seconds in, you are never working again. And so that's why, Your Honor, I wanted to explain to the court why my client has multiple incidents of this, continues the cycle. And as you can see from the text message and other things we've submitted.
How are those statements pertinent to his request for a protective order?
Because they show, really, it's just a first step to show the court why, as you might be wondering, why has he put up with this? Why has he waited so long to do anything? The answer is he was afraid of the force that would happen against him. That's why. If the court doesn't think that's relevant, I'm happy to skip it, but I thought that might be the first question of why did this take so long? Why did he wait from 2023 until now? And the incident is because, unfortunately, and I don't get to say this very often with male.
No, she was threatening that it would ruin his life.
He is coerced either through romantic interest or interest involving his son, and with very charismatic tasks and very charismatic personality to come back and rejoin this romantic relationship until it blows up again. He's subjected to abuse by Ms. Paul. He then goes back and kind of says, okay, I'm going to stop it, and then comes forward.
But if I understand your argument, you're saying it wasn't until she threatened to interfere with his work life that's what prompted him to file for a protective
No, he
order?
filed actually because of the most recent incident when he decided to break the cycle.
All right.
I'm just showing the audio to say why he was afraid to do it sooner. That's
Okay. All right.
all. So that being said, Your Honor, I think there's clearly sufficient evidence under preponderance of evidence, especially with the charge and the plea of guilty, to definitely show that there's been subject to domestic violence. I don't think that's in many ways a difficult argument in terms of him granting a protective order under the statute. However, we have a competing protective order. So let's talk about that. We'll get into the response here, Your Honor.
Well, I want to hear Mr. Swindard make his case in chief first before we get into the response.
Happy to do that. Didn't know how you wanted to handle it, Your
All
Honor.
right.
So, but I'm happy to respond to that once we're
This guy's more professional than David Gingras.
And let me just ask too, Mr. McDonald, I don't know how much input you have as to whether the protective order itself should enter or whether it's more pertinent to the parent time issue.
I don't intend to argue whether either protective order should enter. I just plan to address parent.
Okay.
That's the ad litem.
Thank you.
Yeah,
All right, Mr.
who
Hall,
clearly from the last hearing prefers Dakota over Taylor.
please.
Some hard copies for you, council.
Is this from the thumb drive that I've already received from you? Something new that I haven't seen before?
Everything's been filed
All right.
and provided to council already.
All right.
We have not submitted a thumb drive. That would be from Mr. Mortensen's side.
Okay.
So if I
That's
understand,
right. It was from him. That's right.
I just
But
want to
it-
make sure
Yeah.
that I've got the sequence down correctly in terms of how you want to proceed. My plan was to rebut their request for a protective order and then also drift into my client's request.
Exactly.
Okay,
So it sounds like no evidence
Let me
today.
start with, I think, the primary incident, Dakota's Exhibit 1. We can call this the Barstool incident from 2023. My client has zero excuses for this. It's self-evident that something happened. It should not have happened. It is a tragedy that Dakota and my client's daughter were the victims of her actions. She entered a plea in abeyance for assault on Dakota. She's on track to complete her probation in a few months' time, I believe in August. Don't have excuses for this, but there is a little bit of context to add to this incident.
So there is an excuse.
Very difficult time in their relationship. They were going through some challenges, of course, compounded by the fact that my client was dealing with 2 recent miscarriages. Alcohol was also a massive factor in the 2023 incident, a factor that
Duh.
is no longer an issue. She has not consumed alcohol. As for Exhibit 2, I think this is an important exhibit as well. This is a video that depicts my client slapping Dakota while they were in an argument in her home. Now, my client understands she should not have hit Dakota. The court can take note of that. It's relevant evidence. We understand that. The video also shows some conduct on Dakota's part that I find concerning. Immediately before she slapped him, he took multiple steps toward him, physically squaring up to her.
Yes, he did say miscarriages.
Yes, emphasizing the extreme size and strength disparity of this case. I don't know how big Dakota is. I've heard he's about my size, give or take. When I stand next to Taylor, I feel like a monster. I feel like a giant.
Well, she didn't retreat.
Right.
Retreat. That
It's
is
a
correct.
terrible argument.
She responded how a lot of folks would. She felt threatened
Yep.
if you get in her face like this. He tells her, hit me. And she did, unfortunately. After she slapped him, he berated her while laughing in her face, telling her to shut up. You're toxic as shit. You're fucked. I hate you, and I hate you more than anyone. It's an ugly encounter between these two parties. I think both acted inappropriately. And so I think the court can take some note of that context here. The court was particularly concerned at the April 7th hearing regarding the May 27th, 2025 pushing video, where my client, it depicts her unsuccessfully, I'd say, pushing him out of her home. Now, as she stated in argument on the 7th, as she's repeated and reiterated in her declaration submitted yesterday, she should not have pushed him. The court is justified in being even more concerned about this by the fact that Dakota was holding their son. She acknowledges that. Leading up to this incident, so as you know, Your Honor,
She's
it's
admitting to
brief
a lot of
video.
stuff.
Clearly,
They're clearly going for cross orders and basically conceding.
and there's also
It feels like.
also additional context afterward once Dakota stopped recording. Leading up to the incident, in the days leading up to the incident, Ever had been very ill, and that's a 2-year-old son. Ever had been very ill, and they were having a hard time getting on the same page about how to treat him, how to help him. She feels that leading up to this and during these discussions, he blew her off when she was trying to bring him up to speed. This created a lot of frustration, a lot of tension in the room, so to speak. He came to her house for an exchange right before the video starts. Tempers flared, and she demanded that he leave her home. He did not. This is a familiar pattern in this case. The video picks up with her yelling at him and demanding that he leave. He doesn't. He decides to tell her no, and he lectures her. She then attempts to push him out of the house again while she's holding Ever. Right before he stops recording, she loses her footing and he calls her a fucking bitch. At that point, the recording ends, but what transpires is extremely important for the court to consider as well. And this is rebuttal information, but also something that we would believe give ground to something that we believe would constitute grounds for a protective order in Taylor's favor. She falls to the ground, falls to the floor in her home, and Dakota kicks her multiple times, primarily on the leg. Our Exhibit A, and this is a brief correction, Your Honor.
The May 25 incident.
This is May, yes. There are other pictures that you'll see of injuries to Taylor. Those came in the aftermath of the February. In there, yes.
So
So
many
I'll
incidents.
walk you through
Or
this.
the
but,
ones that were attached to her petition.
Yes, so both. Exhibit A is exclusively related to May 2025. And so I can walk you through those.
I've seen them.
Okay,
So
you've seen that.
this is evidence, though, right? Exhibits isn't that evidence they're presenting?
Different.
Yes, but they're basically just arguing about the evidence. They're not presenting the evidence, really. This is an oral argument. It's not testimonial.
This is multiple pictures, I think 5 or 6 pictures depicting significant bruising on her leg and wrist, all over her leg, shin, knee, front, as well as the side of her thigh. Understandably, she was still fuming about this incident the next day
Well, how's she representing that she sustained those injuries?
while she was on the floor after losing her footing. She was kicked several times by Dakota.
Okay, all right.
The next day.
After the video had
Exactly.
stopped.
Yep. The next day, she's still upset about this, and they're tense in their parenting communications, having some challenges here. So she demanded an apology from him. This is in our Exhibit J. She demands that, this is halfway down the page, you apologize for kicking me while I'm down on the floor. His response is, not in a million years after what you did to me and my son.
Are you saying that's an admission that he kicked her?
Yes, it's a tacit admission. He does not use the words, I, Dakota Mortensen, kicked you, Taylor Paul, multiple times on May 27, 2025. But this was the day after. She clearly confronts him with this allegation. You kicked me while I was on the floor. And he passes by. And he just tacitly acknowledges the allegation.
Is that confirmation? I don't.
Look, it's
I
a
commented,
weak argument, but
maybe optimistically, I commented that both
I think if
sides
somebody said to me,
taken this one back.
apologize for punching me when I hadn't, I would say I didn't punch you.
As it relates to May 27th, 2025, but I was wrong. From Dakota's declaration, his arguments, including the declaration he submitted 2 days ago, he describes a story in which he did nothing wrong. We believe the evidence contradicts this. The closest he comes is an allegation that's not in the video, actually, where he grabs her arm, grabs her wrist to remove it from his shirt, and that's how she got. That explains one of the bruises. And
But she grabbed his shirt first.
Well, she bruised herself by spinning around on the floor, which again, I don't think is credible under the circumstances with the extent of the bruising, as well as this text message in which he, could have refuted this. Related to some of the pictures that he submitted, I mean, these are obviously very difficult for us to respond to, Your Honor. They're in some cases several years old, provided with minimal context, not submitted along with the initial request for a protective order. It's obviously a lot easier for us to respond to the video that he submitted, the videos that he has submitted. But we would just point out that she disputes the injuries that are sustained, that are.
That's a really bad argument.
In these various pictures in Dakota's exhibits.
She just disputes it. Okay.
She has it would be foundational, and she has no knowledge of the incidents.
Of the injuries?
Yeah,
photographs
exactly.
of his
Depicted in the
injuries?
photographs, in most cases being quite old. So naturally, she'll have difficulty responding. Exhibit 9 is an interesting video. It depicts Dakota and Taylor getting into an argument in her home. while he's with Ever, I believe picking Ever up, spending some time with him in his room.
I agree. Lauren for Bachelorette.
And Dakota starts the recording, has it in his pocket. They get into one of these verbal arguments. She tells him to leave. He does eventually. She entered the room, did not kick the door down, as he alleges. He tried in the video, as you'll hear, he tried to get her to admit, you just kicked the door down. And she does say, okay, but it's very curt, very abrupt in an effort to disengage and get him out of the home. Like, okay, Dakota, just shut up and get out of the house. That's how I interpret the tone of the response. It's not an actual admission of.
That's the opposite of what he just said.
What
With
do we
respect to
care about how
parties.
the judge, how her lawyer
Draw the
interprets it?
court's attention
Does that matter?
as we transition now into the events of February of 2026.
Yes,
I
the
want
most
to draw the
recent.
court's attention to our Exhibit I. This is the police report. A lot of interest raised by the court, understandably, at the April 7th hearing about the status of the police report. Where is it? Do we have it? What are the investigators going to do? Are prosecutors going to file charges against any of these folks? Great. And that makes it easy for me. I'll just cut right down to the chase with the police report. We submitted this as our exhibit yesterday morning. As the court has already seen, pages 3 through 17 of the police report contain the meat of the investigation, of the findings. And you'll see they did their due diligence. They kicked over a lot of rocks here. There's multiple verbal and written statements from both parties. Both parties submitted pictures. Dakota submitted some videos. As I interpret it, it's largely the same body of evidence as what's been provided in the respective protective order matters. Very large degree of overlap.
This lawyer is not compelling at all.
On the allegations that took place on February 22nd and 23rd. And in all candor, I think it is
No
helpful.
David Gingras.
You've already read this, Your Honor, so this won't be.
You can read relevant passages if you want me to.
Sure.
If you want to highlight those.
I'm just looking at one that kind of encapsulates what happened, because obviously as outsiders of the investigation looking in, you always kind of wonder, you'd like investigators, prosecutors to kind of show their work, provide their analysis as to their findings. And on page 16, the city prosecutor, this is the investigator's recitation of the prosecutor's analysis on the case. And I'm reading this to be candid, Your Honor. This cuts both ways. This is a mixed bag for both.
Yeah, they're going for.
It certainly doesn't completely absolve my client. I understand that. But I do think it is relevant, so I wanted to just read it briefly. It says on March 20th, 2026, the city prosecutor provided me, this is the investigator speaking, with an analysis on the case. She advised that neither Taylor or Dakota are credible witnesses, with both their statements being fraught with inconsistencies, such as Dakota's statement to 911 and Taylor saying she had a bloody nose with no evidence of that being true. That Taylor most likely injured Dakota on February 22nd, ripping off his necklace and causing the injuries she sustained. And causing the scratch to his neck in the process. Dakota causing injuries to Taylor on 223 while in the truck, because the injuries she sustained do not fit him pushing her off of him. The injuries are more consistent with him grabbing her head or neck and shoving her head against the dash, and that both parties are misrepresenting their behavior. Also, Dakota had told her that he had not spoken to DCFS, and when she had spoken with DCFS, they confirmed they had spoken to him multiple times. They then conclude that DCFS might be the best way to help these folks.
No criminal charges, either way.
Either way,
Right.
city or county, no criminal charges against either party.
The DCFS investigation is still ongoing.
No, it's completed.
Oh,
I'll give a full update on DCFS in just a moment, Your Honor, because I think that's an important point. So we mentioned bruising. Exhibit A, as I mentioned, relates to the May 27th incident. There are a few. This is an overlap with my clients. It is our Exhibit E. If we look at pages 25 through 27 of the police report, you'll see the bruising. You'll see a compilation of the bruising that's referenced there. Page 25 is the large bruise and swelling on her forehead.
Same pictures. that were attached to the petition, right?
There is one different one. There is one additional one that I can show you. That would be on page 26
Of the,
of the police report.
what's the exhibit number?
That would be Exhibit I, Your Honor.
Yeah, the kids need help. I feel horrible.
Do it. It's a long exhibit.
Right, it's numbered. I'm looking at page 26.
Okay. 26.
Where is the father of our other children? Why doesn't he have custody of them?
She's wearing,
I don't know what Tate's deal is and
Yeah,
all
you
this.
can see the bruising on her shoulder. This is
I mean, if he was married to her, he can't be a peach. So probably,
these pictures tie together. So we go to Dakota's allegation. The Dakota,
this is still from May, right? May of.
no, this is related to the February 23rd
Oh,
incident.
I see. The one where you said we didn't have any videos up.
is that better? I'm trying to whisper as quietly as possible.
So this sequence of pictures, again, relating to February 23rd in the truck, neither party, there were no other parties present, no recordings, no audio recordings.
This began in the house, right? And they moved out
Yes.
to the truck.
Does anyone in the chat know the status of Tate's request?
Yes. So they were intimate in the home on the 23rd, and then
This was
Dakota-
at her place, right?
her place in Draper. Dakota wanted to talk about the relationship, knowing the volatility and where these often go, with folks getting very animated, yelling at each other. Taylor acquiesced on the condition that they go outside. So they went outside. Dakota drove away against her wishes with her in the car and then assaulted her. And this three pictures, these
Away
three,
from the house with the child alone inside the house?
correct.
Is Dakota drawing
years old?
pictures?
Yes. So,
How far away?
well, as he tells it, he kind of did a loop. So he stayed in the vicinity,
Okay.
but drove away against her wishes. The reason these pictures are important is
The
because
child is
what-
2. They
what
can't be in the
happened,
house
right?
alone.
You've got two different narratives here that are at odds. We're in the truck on the 23rd,
Thanks, Lauren.
and they're both pointing their fingers at each other as far as
You guys are funny.
they assaulted me. These pictures were extremely relevant and persuasive to law enforcement because Dakota's narrative is she went crazy and I had to kind of fight her off of me. And in that scenario, in that sequence, yeah, I did, push her head against the dashboard. He admits that in writing to police, but it's within that context of it's defensive. But the prosecutor and
Have we shifted from response to his petition to initial argument on hers?
yes,
All right. Okay.
if that's okay.
That's fine.
Okay, all right. And it's a bit of both. I mean, if both sides are claiming assault as it relates to February 23rd,
They're the same
there's
incidents.
gonna
You
be some
can't
bleeding over.
separate. This is silly.
So with that clarification, Your Honor, again, investigators and prosecutors looked at this sequence of pictures provided by Taylor, and they contradict what Dakota said about what happened on the 23rd. These are not defensive bruises that Dakota inflicted on her. These are bruises that depict her left shoulder. So again, she's sitting in the passenger seat. These depict him forcefully grabbing her shoulder and sending her right into the dashboard. There's also a picture of bruising on her arm, which occurred during the same incident when he struck her.
If he did that with a lot of force, she's not going to have a little bit of
Now, again, we've
injury.
switched gears a bit and kind of drifting into my client's request for a protective order. As it relates to Dakota's conduct, my client has seen patterns of abuse and isolation, harassment over the years. And she would like to highlight just a couple of things that kind of speak to his inclinations, speak to what his desires are for her.
Is that
his
Leanne, her
possessive
mother,
nature.
behind her?
We have submitted as our exhibits B and K, a very small glimpse
I think it is.
into his obsession over Taylor, his inability to move on and leave her alone.
Okay, but she's constantly going back to him as well. She's accepting of it. I just don't know if
Perhaps the
that's going to be
strangest
enough
exhibit
argument.
of the hearing will be our exhibit C. It's a 3-page sequence of pictures that depict a tattoo that Dakota received on the inside of his lip, his lower lip, of Taylor's initials. This was done without her knowledge, without her permission, and during an extremely difficult time in their relationship. It
So
was
what?
unwelcome. She told him that. As soon as she found out about the tattoo, she told him that, labeled it creepy, and he just doubled down on it and denied that there would be anything objectionable about it. Dakota does attempt to muddy the waters. In his statement filed this week, he does attempt to muddy the waters on this issue. He attaches a text message in which they claim, Taylor implies that she liked the tattoo, finding it quote unquote hot that he had the tattoo.
This is
That is
really
not a fair
bad.
reading of the text message. It's clear that she's mocking him for having the tattoo. She's essentially telling him, I'll be thinking of your silly tattoo while I'm with other guys. It wasn't nice that she said that, but that is the context, and that is the correct interpretation of what she was attempting to convey, not meant as a dig at him. It was meant as a dig at him, not a genuine expression. Another objection my client has regarding Dakota's conduct over the years that, again, shows
That's her objection.
her inability to let go, his monitoring of her, is shown in our Exhibit K. This is at the very end of our exhibit packet, Your Honor. Very briefly, this demonstrates that there are two instances. There were two instances in which Dakota stole Taylor's phone. Specifically, if you read these,
This is him talking in this text bubble, in these text bubbles.
Yes. And so, for example, if you go, so Exhibit K, pages 8 and 9, if you go to the second to last page in this exhibit, that is page 8. What's being shown here is the first instance, did you steal my phone? So weird, and she confronts him about it, and he downplays it. The second instance is depicted on the final page here. You stole my phone again? He says, yep, wanted to read all
This
the
has vibes to me of like Laura Owens trying very hard to prove her pregnancy when she wasn't pregnant.
The response was, oh,
It's like they're trying to prove abuse
so
when there is
I
none.
understand that he had crossed a boundary, that this was invasive, that it was at a minimum improper for him to be observing and intruding on these communications that he imagined she was having. Finally, Your Honor, I do want to,
Finally, Your Honor,
as it
this
relates
news
to
overstood.
abusive conduct, I do want to touch on something that is a little unusual about this case. There are a few aspects to it that are a bit unusual, but this is one that my client and I find, I think, relevant, and that is a very public leak of the 2023 Barstool incident to media outlets, one specific media outlet, TMZ, on the same day that Dakota filed his amended request
You're
for a
talking
protective
about
order.
the affidavit from Draper.
Yes.
Okay.
Yes, she touches on that. Yes. So you're correct that a declaration from Jesse Draper was filed yesterday afternoon.
Okay.
And so I'll get to that in just a moment, but to provide a little bit of context, last year.
Yeah, I agree, guys. This is not good lawyering.
DC's Bachelorette. Filming took place in the fall. The season was supposed to have debuted on March 22nd. However, on March 19th, the same day he filed his amended request for a protective order, a news outlet published the video of this incident. Before this release, it had not been out in the public. So this was released 3 days before the big debut and coincided again with other actions he was taking with the protective order, as well as coordination, additional reports to law enforcement. I understand he denies having done this, but a lot of information lends itself to Dakota leaking this, or at least at the very minimum, having his fingerprints all over this. In addition to the timing, which is extremely coincidental, the declaration of Jesse Draper, which you alluded to, Your Honor, indicates that in the days leading up to the March leak, Ms. Draper entered the basement of her home, that's Ms. Draper's home, to find Dakota speaking with Ms. Draper's husband, Jordan, as well as Dakota's roommate, Crew. And what they were talking about, she noticed that he was very animated, that Dakota was very animated. He was venting his frustrations with cops not doing anything, and told her he was going to take matters into his own hands to embarrass Taylor. He specifically told Ms. Draper that he planned on leaking embarrassing videos of Taylor to the press starting with the Barstool video. He specifically named TMZ as the outlet, and a few days later, that exact video was released by TMZ.
Okay, so that's new
Point in
news.
bringing this up, Your Honor, is that it contradicts how he is attempting to portray himself today as someone who is really he does not want to come after her for custody. Excuse me, Your Honor. So our point with the video,
This guy's bad.
he's not just trying to come after her for custody. He's not just trying to seek a protective order. He wants to literally destroy her. He wants to subject her and her family to a new round of torment. Yes, there are career implications to it. There's mass embarrassment associated with that. But ultimately, our big problem with that, my client's big objection to his conduct was, this additional harm and embarrassment and shame that he inflicted on my client as well as her children. This was a step too far, and we think shows his true nature.
All right.
He got
I
like
do have comments on
35
custody, but I'm
minutes.
guessing you want me to hold off on those for the time being.
Just for now.
Okay.
We'll come back to it.
Great. Thank you, Your Honor.
We're an hour in and neither of them have taken the stand.
I don't think anybody is taking the stand.
Rebuttal and response, yes.
Right.
So now his
Then
rebuttal.
when we get to the parent time issues, I'm going to start with Mr. McDonald. And we'll work our way around.
Sounds reasonable, Your Honor. Okay, so let's take a look at, we'll do response first, as I think that will kind of square up, and then I'll rebuttal for kind of the entirety for that. So I see 4 allegations in her protective order against my client. I'll go through them line by line, Your Honor. The first
This
one
is the way to do it.
in opposition with its exhibits. I'll try not to burden the court by reading it directly. Regarding the May 27th, 2025 assault, as you can see from our declaration, my client reports it was actually stricken before he turned the camera on. Once the camera's on, you can see her acting extremely violent against him. When he was able to turn the camera off, remember, he was holding his son. She was grabbing him. You see the information that we have here. We suspect her injuries were occurred from her phone.
I'm more interested in his explanation for her injuries.
So the wrist is likely because he had only one harm as holding the kid to try to get her arm off because he was trying to get out. She tripped. And I think the tripping and the kicking on the floor is likely where the bruises to her legs happened. He does not believe he ever kicked her at that point in time. And I do have some interesting bit about
He
that.
doesn't believe.
That's so, you never say that.
It's a little hard to figure out exactly where things were, but he does not, he will definitely, if I called him to testify, I would testify he did not intentionally kick her in any way. But when you have someone falling on top of you and you're trying to get away and you're trying to hold your son, legs can kick out, you can fall backwards. He was trying to hold his balance. He stepped
The
on a
video
toy.
show him falling down.
No, the video stopped before that. That's the unfortunate.
He was able to turn it off while he's falling.
No. He did not fall. He started to fall as he fell on the toy, tripped on the toy. And that's when he realized, okay, I've got to get my hand. So he turned it off. So
All right.
That's what he says. And I think that makes a lot of sense, Your Honor. What I think is really interesting about that is the rebuttal exhibit that I did cite, Your Honor, is
Great camera.
she indicates,
I know.
I believe it's rebuttal exhibit 4. There's a text message stream where she actually indicates, and this is from a year, May a year ago, that she has her video of the incident and he has his. What I think is interesting about that, we've never seen her video. Which leads me
Right.
to believe she was either being untruthful and she never filmed it, or she did have a film and she's not showing it for a reason.
The fact that he's the one with all the videos, to me, is compelling evidence because an abuser doesn't video their abuse.
Important to recognize. I also, really want to put this in perspective. He is holding his kid at the time. He's trying his best to leave the residence. And so that's where we're at. Also, as you can see here, let's move on to the next one. I did want to address the police report really quickly, Your Honor, before I forget, because it's not detailed here. And that is, remember, police are always looking at beyond a reasonable doubt. It's a different standard of proof. These injuries, that was photographed, there is no, kind of nothing but her testimony or her statements that they were inflicted by him. And there's nothing but his statements as well. This is not someone.
February.
This is the February incident. There's nothing, no one recorded, everything was done after the fact when police were called later. And that's the problem. And it was like, I think 2 or
What's
3 days
odd to
later.
me is that from May of 2025, there's video and photographic evidence, but no charges either way.
I know, Your Honor. It's a little odd too. And I'm a little surprised as well, especially since
It's not odd to me at all.
court probation at that time. or not just court, I think, well.
That's what's odd.
Correct me if I'm wrong, but she was under AT&P probation for one period of time, and then it went to court probation. So the fact that that didn't come forward, it's why I mentioned earlier, Your Honor, that stuff about him not coming forward. It's because I think that's the oddity, is why doesn't he tell the DA? Why doesn't he do these things? Because he was afraid.
Okay.
And so now let's head over to the February 22nd incident. You've seen our response, Your Honor. You know, we see text messages. She indicates in her protective order that he was harassing her and trying to come over and trying to hook up. The text messages that I submitted, extremely clear. She invited him, and she invited him for the sole purpose of intimacy. And I think that's extremely why we keep seeing this cycle happening. And he did go over.
I just have to back up. I mean, they entered into the stipulation for 50-50 custody in June of 25.
I'm
right?
aware.
After this all happened.
Yes, I'm aware.
Okay.
And that's part of the problem, Your Honor, and I'll get to custody in a second,
We'll
but
get
that's
to it.
why I mentioned those issues, is that this is a man who I would expect a lot of male domestic violence victims are, is he's trying to make things work, he's trying for the sake of his kid, and he's still enticed. He still has this spark of romantic relationship that occurs, but then it's a cycle. Then it
The troubling part about this is like it is so well known
Oh, I'm sorry, here we go, and you can
that
see
people wait years
the
to
scenario on
report
the
abuse.
second incident where we're talking about the broken necklace. You actually submitted the text where she said, I bought you another necklace. Well, I can quote it, but I bought you another necklace for the 1,000th time.
All right.
1,000th time. That's a pretty good statement. These are being ripped off a lot. And he can find the information he can, but, you know, and the pictures he can, but that's where we are.
For the person who just said they know family court in Utah,
See,
who
on the
cross-examined? When do they cross-examine the parties?
They
That's what I'm wondering.
On top, strangled him, pulled his necklace, broke it off. We have the text messages that support that. And then we have again, well, that one I do want to mention. He did call 911 that night. That was the first inkling because he realized he looked over at his son, saw his son terrified and crying, and went, I can't do this anymore. I can't do it. I've got to take it. I can take it. My kid can't.
This is, are we
February
leading into
22nd.
26 now?
February 22nd, 2026.
Judge
one
gets
where
so
we don't
confused
have
by what
any-
incident you're talking about.
Well, the problem is the convention is usually you say the February 2026 incident. You don't say the February 22nd incident. That doesn't help. It doesn't matter what day in February. It matters what year.
And so he makes something up and says, oh, well, we're wondering if the kid's sick, because the kid was sick earlier that day. It's not a lie, but he chickened out. He didn't tell police I've been assaulted. He didn't want to face that wrath. And so he left. The next day, February 23rd, you know, it's the next day, early morning. You can see the text message we provided. She entices him again, specifically saying, come over here. I need intimacy. I'm paraphrasing it in a nice way because we have cameras, but
Didn't he
it's not that
engage
nice in the text.
Similar kind of behavior himself
Yes.
in that regard.
Yeah, there is some of that as well.
Both
yes,
of them.
course.
I mean, we've all seen it.
Yes.
4 seasons of this show.
You know, requesting or having, you know, sexting back and forth and not grounds for a protective order. But in this case, I'm presenting it because it conflicts with her narrative that he's this stalker that is somehow always
Right.
her
That's why he's
opportunity.
doing
He
this.
specifically requests it. He specifically goes on the 23rd. They have a whole discussion about where they're going to be able to do it because it has to be downstairs because the kids are there and they're sleeping and this and that and this. And they go down there and the same thing happens. But this time, she throws things at him. She throws his phone, breaks into the wall. It like sticks into the drywall and he had to pull it out. That's probably why he didn't record. And then he runs out to the truck. And while he runs out to the truck, she follows him as she was trying to block him from leaving the residence. It's not the actions of someone who's.
So here I just have stories, right? For
This
me,
is just stories. We just have their story and our story.
proffers of testimony.
Proffers of testimony. And he says that she.
Except maybe for the one exhibit that she said occurred from what transpired in the truck, right?
Yeah, well, we have the police report, but their statements pretty much follow exactly what we're saying here, Your Honor, which is he says that, and it's my client, that, and I think if you look at the history of this case, it's the more credible retelling, that she follows him out. She blocks him by getting in his passenger vehicle so he can't leave.
Yeah, Bruce, you're right.
Said, I'm calling police, I'm done. Okay? She doesn't want that to happen. She follows him. She has got a lot on the line.
Usually the
She
witness
follows him, gets in the car. This has happened before.
doesn't have to take the stand to present their direct testimony. They submit a declaration or an
She sees a
affidavit.
text message come through.
So that's the witness statement.
Through from some girl that he's seen. She starts kicking and busting the video screen thing that we have, you know, in our trucks or our cameras in our cars. She starts, she didn't break it, but she was hitting it. Then she starts, striking him. He's like, well, I better, try to get out of here. So he starts driving. He starts driving around the block. Hopefully she'll calm down, because he's good at calming her down usually.
And this is all led to the police report
This does.
that said that concluded they both had credibility issues, right?
Right.
That's correct, Your Honor. The police report believed that. I don't think my client has credibility issues, but I think when the DA's office is looking at it, they're going to make a call, and I would humbly suggest that they didn't want to get involved in this. So they said it both ways.
I agree.
But credibility for her, I mean, we've got preponderance here, Your Honor. The next up is, just to cover it, she started interfering while he was driving by squeezing his face, taking him. That's why he throws her off of her. And that's where I need to cite a statute, Your Honor. I think that's the important
You
thing
have
for this case.
photographs from that
No.
incident?
No. Well, I mean, later, with the police, they took the necklace and stuff like
Right,
that.
right,
But squeezing the face, I mean, it didn't
I haven't
leave
seen
any
those,
marks.
have I?
The necklace photos were in our original exhibits,
In
Your
your
Honor,
original.
the scratches, yeah. But here's what's important, I think we need to quote here. Section 78B 7108, mutual protective orders. I'll get to refer to the statute very often. When two parties have filed protective orders, the court may not grant.
It's the same in California. This is what I've been saying.
Opposing parties, unless each one's filed their own, that's happened. And there's a showing that, there's basis for it. But it becomes the party's burden, including Ms. Paul's burden, to demonstrate that the abuse or domestic violence she's claiming did not occur in self-defense.
Yeah.
We're saying it's self-defense, Your Honor. He had to stop the attack. He did push her off. It's possible she got a bruise to her head. He didn't see anything. He didn't see a bloody nose. She said her bloody nose. He went back the next day. There's no bloody nose. She's not saying anything. It's in the text messages. We think the credibility there is, it's very easy for her to, if she's attacking him, to harm herself or to get hurt by hitting him. It's very easy for her to push. He is stronger, and she gets thrown into the door as he's trying not to crash the car, where the kids are at home alone. So he goes there, pulls off, she gets out, and here's what's interesting. Okay, and this is why I struggle with the credibility of Ms. Paul's statements. That right after that happened, she proceeded to call him 11 times, and we submitted those phone logs. You can see them 11 times. And in the very first one of the calls, he would say, because it's not recorded, it's called, she actually says that phrase that she then used later and to say he's this harasser, so you don't want to fuck. That's what she said in the first call after this whole thing happened. That's what she says. In which he was like, what are you talking about? He said no. He gets 10 more calls from her. So the phone numbers, submitted them, saying that they should return. She then says she has a bloody nose. He's concerned, so he goes there because she says, again, using the kids, I need to go to the ER, someone has to watch the kids. He goes, tries to get in, knock on the door. She won't. Sees through the window, she's there, there's no bloody nose. And so he leaves. And you see the text messages that we provided. You can hate me, it's valid, she says. He says, finally, the intimate relationship's over. And we submitted those text messages. I think it's really important that he's finally had the courage to break this cycle, Your Honor. But I need to respond to a couple other things as well. So next up.
I think this lawyer's much better.
Here it is.
Not much better.
It seems
A
like,
little better.
She claims
seems like he picked up the
that,
points
there's
and
been
says, okay,
harassment
this
in
is
this case. I do need to cite what the definition of harassment is, Your Honor. Harassment, as defined by, and the Protective Order Code does reference this, 76-5-106, which is the criminal code for harassment. An actor commits harassment if, with an intent to frighten or harass another, the actor communicates a written or recorded threat to commit a felony. There's no evidence of that here, Your Honor.
Oh, that's very interesting.
It's not harassment. It's not a basis for a protective order. February 23rd, we've covered. February 14th, the harassment and stalking. Again, for stalking, Your Honor, I need to cite Meyer v. Potion, a case I'm sure you're familiar with. In that case, it talked about the reasonable person standard. It's not whether she feels it's stalking harassment, Your Honor. It's what a reasonable person would believe. And falling into that, when we look at it from an objective standard, the one piece of evidence she really draws on is this tattoo. Okay? And
so she's saying
Oh,
the
and
tattoo
just-
was
because
harassment.
I forgot about it, but in Exhibit 10, which
No.
happened right after
No.
the incident, the 23rd, we showed you the phone logs. She made 151 phone call attempts to him between 2 hours.
That's what I posted on
So
my
the
Instagram.
behavior of someone who's afraid and worried that she's been abused, behavior of someone that's afraid that the abuse is going to happen. So February,
Yeah.
it sounds bad. You know, when I first heard about this tattoo thing, I went, geez, Dakota, what are you doing tattooing something on the inner of your lip? And he gave me an explanation I wasn't prepared for. Makes a lot of sense. It was a filmed segment of the TV show, Your Honor.
That's what I heard.
All
That's
the
great.
That the other guys
decided to
did.
go down to the tattoo parlor as part of the Secret Lives TV show. It was filmed. It hasn't been released yet. They all get tattoos, and they all think, oh, it'd be so funny if you put Taylor's initials in your inner lip. And it's something else I didn't know until I looked into this. Inner lip tattoos, the reason why people do that is they fade.
They fade.
They go
Yeah, that I knew.
I have no idea whether that's accurate. And I don't have any
I will
expert
proffer my client's
to that.
testimony. In fact, if you want, you can
One
probably
way or
show
the
you.
other.
It's not really there
All
anymore.
right.
So that's why. So it's not something that shows or permanently affects the bodies. What I think is really important with that is he was there with the group. It was filmed. When it comes out, we'll probably all see it. And what's important with that is, more important is that you could absolutely see in the messages that we provided, the text messages. Yeah, I mean, they're trying to say she was just horrified by it, but no, she actually talked about how she was, say it's kind of, I mean, I'll soft sell it as a turn on, but my client would proffer his testimony right now that that very night of those text messages that you saw of her allegedly being freaked out about it and thought it was possessive, they were intimate that very night. So this is not a stalking, harassing behavior. These are two people that are on a TV show doing all these different things.
It's a good argument.
Thing as TV is, but that's not stalking behavior. That's not harassment behavior. Yes, my client will admit this is an inappropriate relationship. It needs to stop. That's why he filed his protective order. But the main issue here, when you look, and I guess we're doing rebuttal as well. The main issue here that we have is his desire to protect his son. That's why he filed this protective order, is to protect his child, to stop the violence, to make both himself and her not be able to have contact. Now, this is a small thing, 150 days. It's not going to be that long. We've got a lot of work to do in the custody case. We've got DCFS involved. We're going to get to the bottom of this and sort it out and get some help.
Oh, it can only be for 150 days?
And that there's some behaviors that were deeply concerning that we've seen from Miss Paul when she gets emotional and she gets aggravated. I definitely wouldn't want to be a child around that, and that's something we can work on. He believes she could be a great mom. She's a great mom when she's not emotional or not under these things. That's the problem. But we believe her protective order was filed minutes before the first hearing on April 7th.
Yeah.
Designed to protect her son, it's designed to protect her image. And her image has a lot of value. And so that's our argument in terms of credibility. I also did bring, I can proffer the witness, Your Honor. I don't think it's relevant about this going downstairs and the witness hears them talking about whether he's going to release the video or not. February 23rd video. We have a lot of February 23rds. The 2023 video.
Exactly.
The chair video. I don't think it matters from a legal standpoint whether or not he releases it or not. That's not a basis for a protective order. But just to show the credibility issues, he denies doing that, Your Honor. In fact, he told his publicist not to release the video. And I do have, Your Honor, someone who was downstairs with him, and that would be Mr. Crew Eaton, who's present, and I could proffer his testimony.
I read what in the police report. Apparently, he's the one that called the police, right?
Oh, the roommate? That's someone different.
Crew Eaton, he was the
Oh,
one.
no, the same person, yeah.
Yeah.
But Crew was down there at the time, and if I point to him, and he can correct me if I'm wrong, he would say that Dakota actually kept saying he didn't want to release it. Didn't want to release the tape. Like I said,
I don't
not
need to
terribly
hear
relevant, exactly. So, Your Honor, I'm happy to talk about custody if you'd like to hear from that. You said you wanted to hear from the GAL first, but that's where we're at, Your Honor.
GAL, guardian ad litem. Boom! I'm so
That was loud. Yeah, but you got to be not so loud.
Taylor's request for.
Oh.
And after rebuttal,
Oh, this guy again. Jesus.
still like
Oh, no.
custody
Yes.
before we drift into that. Okay,
I
understood.
mean, I have the domestic case too, so I don't know where this is all going to be honest with you. Are we going to be keeping coming
Oh,
back
so-
periodically for time immemorial? We'll see.
Hopefully we
Okay.
can avoid that.
What the judge just said was, I have the domestic case too. The
word
paternity
side-
case is assigned to this judge as well.
A lot of back and forth, a lot of toxicity in this relationship for a few years now. My client, she is taking accountability for her role in that. She's owning her, not just her participation.
I would show her
Conduct that relates
public
to
posts saying, no, she doesn't.
the protective order, Mr. Mortensen's request for a protective order, and she's provided some context and some accountability for that. Mr. Mortensen does not own anything. He's not owning up to anything in this case. His strategy is extremely simple: deny everything. His only crime, as he tells it, is to give in to her advances. No mistreatment by him, no abuse, no violence of any kind. My client has shared her version of events regarding her request for a protective order. Again, the May 2025 incident does stand out. We got an interesting characterization of it today.
I do want to ask, and just from a credibility standpoint, she was texting him saying her nose was gushing with blood, but there never was a photograph of that.
Well, let's just keep the sequence straight. That was a different incident, which I'll come to in just a moment. That's
all
yeah.
right.
I know that there's a handful to keep track of here, but the May 2025 incident is her pushing Dakota and Ever out of her home. That's the one I'm referring to right now.
Okay.
All
right.
So again, this one stands out because there is an admission, a text that we believe operates as an admission
Well,
that he did kick her.
there's photographs too. Yeah.
Photographs of bruising, and
The judge is clearly persuaded.
defense, came awfully close. I would say he did acknowledge that his client did kick Taylor while she was on the floor, but there was some
Said he
vagueness.
proffered that if he were to take the stand, he would say he didn't recall kicking.
Yeah, he may have, right? And then speculated that, well, it would have been a natural
He
response.
was being attacked at the time.
Right.
That's what his argument is, self-defense.
Exactly. Yep, I understand the argument. I just don't think it's very credible under these circumstances, especially with the photos of the bruising as well as the text message. The February, now we're skipping ahead to the bloody nose, Your Honor. The February 23rd, 2026 incident. We need to evaluate this and scrutinize this one as well. What the evidence actually shows, despite what he has alleged regarding this, what the evidence demonstrated to investigators, and which we think is more credible, is, again, he assaulted her, violently grabbing her by the shoulder and throwing her into the dashboard. I looked through his declaration from 2 days ago. I don't even think he acknowledges that his force sent her into the dashboard, but he acknowledges that in his written statement to police.
All right.
So he's having a hard time kind of keeping his story straight and providing some context for her injuries. He did, after that incident, he did finally drop her off at her house. He feared, and this is not me speculating, this is what's going on in his head according to his statements to police. He feared that he injured her. Shoot, maybe she has a bloody nose. And that's why he did not call 911, which I think is curious.
And he didn't, but she didn't either.
Right, but what my point is, he's saying, I was about to call 911, but I thought I injured her, so I'm going to go to her house and see if I can contain this chaos.
What?
Which I think implies guilt on his part. So he
I
returned.
don't even understand that.
That seems like a breach.
The incident, did she text him saying there's blood coming from my nose? I think in that reference, though, he was asking for a sexual relationship. That's how that, preceding that comment that she had made about her nose bleeding. Right?
This was, as I understand it, in the immediate aftermath of that, so minutes after.
All right.
So not hours or days, very soon after.
Okay. All right.
Which I think is curious.
But she took a photo of the arm, the bruise, but not the face. That apparently was.
I mean, that's the end to me, credibility wise. She's got a gushing bloody nose that she doesn't take a photograph of.
Yeah, we have.
But she takes a photograph of the little bruise on her arm.
But I mean, she got around to taking the photos after the bruises developed, and she should have taken a picture of the bloody nose.
Yeah.
And again, this is the instance where he claims that she just assaulted him, and yet he goes back and asks for sex. And we'd object as to foundation, as to these call logs. The call logs that have been submitted and evaluated are all over the place, difficult to follow in terms of the dates, the timestamps. Some of these communications show that these are outbound calls from Dakota to Taylor. Some are coming from Taylor to Dakota. And so we don't think that it actually lines up and demonstrates that there's 100 missed calls from her on one of these days. So we believe that these instances, among other things, among his possessive behavior, which we've outlined with some examples in our exhibits.
It's a bad argument here.
Vindictiveness in terms of trying to, again, go one step ahead of things and ruin her life with the leak. We think that this will be important to have a protective order entered for her. She'll certainly benefit from it, and she's met the grounds for doing so.
Is
You have
that
a
the
couple
standard?
on his protective order as well, Your Honor. She's trying to take accountability, and she has done so in this case, related to the bar stool. Can
Can I ask
certainly
a question about that too?
sure.
Didn't she make those same arguments at the time of her criminal sentencing?
Yes.
Yeah, I
Taking
presume I was not involved in that, so I don't know exactly what statements she would have made.
All right, okay, all right.
But we believe the court has discretion, certainly, to enter a protective order in Dakota's favor, but it's not mandatory in this particular case. He has shown zero fear of my client whatsoever, which is an element. It's not a silver bullet. I don't know that there is a silver bullet, but it is a relevant element to consider here. You can see it in his expressions and how he communicates to her during.
It was totally, that was before my time. So generous.
He eggs her on, laughs in her face, insults her relentlessly. You can see this lack of fear in how he pursues her over and over again, love bombing her, manipulating her. Examples of these possessive overtures are included as exhibits B and K in what we've submitted to the court. We can see this in how he's working overtime to completely destroy her. He is obsessed with this woman. He's not in fear of her. Those are different issues. Likewise, the court can and should consider the passage of time of many of these instances. The court understands that you are prevented from only relying on a passage of time, but we still think it's relevant in this particular case. If he was in fear, if he's truly been in fear, trapped in this violent relationship for over 3 years, if he truly considered himself a victim who needed protection, why would he instead just sit behind a camera and just stash embarrassing, difficult moments in their relationship? It's not really in line with what we'd expect, how we would expect the victim to act. And so we are asking for entry of a protective order in her favor.
Isn't that exactly what a victim would do?
Yes.
Record
I
this
want
stuff?
to switch gears and go to the parent time issues. I want to start with.
All right,
regarding
parent
the
time
item,
stuff.
And see where we go from there.
And Your Honor, I'll be pretty brief. Frankly, since we were here last time, my opinion and recommendation hasn't changed, and it's still based on the same argument that I made previously. I've reviewed all of the new information. I tend to agree with the police report that as you read through everything and look at the evidence, it's difficult to find credibility with these February incidents from either party, frankly. My concern goes back to the initial incident in 2023 that didn't involve my client, who wasn't born at the time, but did involve I guess I can't say petitioner or respondent because they're both petitioners and respondents.
Mother and father.
Yeah, correct. But that incident was alarming to me because of the chair being thrown with the child sitting right there. I know it wasn't intentional it wasn't child abuse in my opinion. She wasn't intending to throw the chair at the child. She was intending to throw the chair.
Direct child abuse, but it certainly was domestic violence in
They-
the presence of the child.
Charged it as reckless child abuse, but it also, that got dismissed as part of the plea deal. Nonetheless, when you read through the probable cause statement, it's a concern. I mean, they're fighting, the child's sitting right there. You know, domestic violence related child abuse can be a little bit interesting in that sometimes you might have a child in the room next door, but the child's not in like direct harm. In this situation, the child was in direct harm. The child was sitting right there, the chair hit the child in the head. And that didn't, that didn't stop her. It didn't stop her actions. Again, she pled to the charge. She did the DV assessment as part of her probation. She's complied with probation. She completed, from what I can tell from the probation report, everything that she should have, and she should have learned from that. And then we go back to this May incident, and I understand, and I said this last time, there's a beginning that's not filmed and there's an ending that's not filmed. But what is filmed is Mr. Mortensen holding his son and Miss Paul coming at him and pushing him and pushing him. And I don't think it's the trip incident that has been discussed, because it sounds like that happened after the camera was off. But you can see Mr. Mortensen, you can see the camera go like this, and then it kind of ends. It's clear to me, I mean, that was, again, putting my client at risk of physical harm. If this was a situation where the domestic violence and the fights that had occurred were done in the presence of the child, and the child wasn't specifically in physical risk, or if, you know, there was kind of a wake up when these things happened and it stopped, I might not be recommending supervised parent time, but I am really concerned about, like I said last time, Ms. Paul's ability to control her behaviors in these situations.
Well, I mean, this is the question I have for you, which is I don't see really that there's any other, let's say no criminal matters I could find regarding Dakota, and the only criminal matters that were found had to do with the interactions that they had with
This judge, it seems like, doesn't even care about the guardian ad litem.
too, as well. The injuries, it's all, these are all relative to interactions the two of them are having with each other. What's the risk in terms of to the children if I'm keeping them both away from each other?
I think the risk is that when you have someone who perpetrates domestic violence or is involved in domestic violence, and there's no sort of learning to control the behavior, I think the risk is that there can be future relationships with other people.
Exactly.
Those relationships can
The
lead to
child
violence again.
himself when he gets
There
older.
can be additional fights that happen with other people, but I agree, there's no criminal history there. It's just those two situations were extraordinarily concerning to me because there wasn't that sort of wake-up call when the child was put in harm's way. And
By the way, I agree, they both suck.
There's a lack of control there. My thought is that the family is working with the division. They're doing services with the division.
What happened with the case closure on the DCFS investigation?
Supported mom for DVRCA and supported dad for failure to protect.
Yes.
Both were supported.
Correct. One for failure to protect, the other one for DVRCA.
Right. So dad,
The division is
they said
providing-
dad was failing to protect the kids
What I
from
would like to-
mom.
What I would like to do, and I understand that the court has the primary custody case also, and so, maybe this isn't the best idea in the world, but what I would like to do is set a review date and come back in about 60 days and see what the progress is on the DCFS cases.
Do we know what services are being,
I
what
do.
they're doing right now as part of a services plan?
I do. I'm a little bit hesitant to discuss it on the record, but there's going to be some assessments done by both parents and then follow the recommendations of those assessments.
TV assessments?
Yes, and mental health assessments.
Okay. So this is not voluntary, it's
At this point, it's voluntary.
void filing of a child welfare petition.
That's essentially it. So I think that they would call it voluntary because there's not court orders. But I think that there has been discussion of filing child welfare petitions, but for the agreement to do the services.
Well, this isn't juvenile court. I can't take the kids away
Correct.
from both, child away from both of them. and
Correct.
Right.
supervise them both, right?
Correct.
But what I think I hear you saying is you're more concerned about her conduct than his, though. I mean, any concern about what you've heard with respect to his conduct? And yeah, I mean, absent her behavior, I mean, there's certainly under certain circumstances, I might consider supervising him as well.
And I understand that too. My biggest concern, well, I'm not going to sit here and say I don't have concerns with his conduct. I mean, I've listened to the audio, I've watched the video. I don't understand from his position how when he's being attacked, rather than booking it out of there, which would probably end things, he pulls out a camera and films it.
Well, I had those same thoughts.
Yeah, that is a concern for me. But his actions, as I see it, he's not throwing chairs that are potentially hitting my client.
Right?
He's
There's a difference.
holding my client and backing up when he's getting pushed.
There's a difference. I have some thoughts about that too, about the nature of each of their behavior.
Yeah. With that said, I mean, I don't disagree. I mean, it's 2 years that my client has been alive, basically, and he's been exposed to this for that 2 years over and over and over.
Way too many times.
And Mr. Mortensen has an issue. I mean, that's why they supported him for failure to protect.
Yeah. Okay. All right. Okay. All right. Let's go. We'll go back to Mr. Hall, you'll be up next on the parent time issues.
Well, Your Honor, that's why, and I do take issue with it continually saying that Dakota isn't taking, or Mr. Mortensen isn't taking responsibility. That's the responsibility he's taking. He believes he needs to break this cycle of continuing to essentially fail to protect by not withholding, not saying, no, we're not going to come back. I'm not going to take your text messages again. I'm not going to expose my
Well,
child.
he could have done that
could've.
way.
He could
But
have.
he chose instead
doing
to
it
file
now,
for a
but-
protective order.
That was his method of saying, I'm done and we're
Stretch
over
is
it.
scary.
And I think
Right.
that's a good way to do it. And we shouldn't blame people for filing protective orders to assist them with that.
Well, your argument though was that hers was in a sense retaliatory, but
I think there's a
there's some
component to
evidence
it.
there that, in terms of her bruising
And,
as
and
well, passage of time. In one sense, you're arguing we shouldn't be dismissing his request due to passage of time, but you were suggesting maybe I should with respect to her.
no, hers, the most recent thing we're saying, it's just not credible. It doesn't rise to the level of domestic violence or abuse, Your Honor, what she is saying he's done to her. He's trying to defend himself and leave. We have ample evidence presented that she has committed domestic violence and abused him. So we only need one protective order to keep this running. And his is to protect, we only need one to separate the two and do this. If he violates the terms of the protective order, I know it's not a criminal violation, then, she can say, well, you're back here again. And trust me, the division won't like that either. But in terms of custody, Your Honor, I think what's really, I've got to cite CCW. And CCW does state, which I think is really important,
What's CCW?
emphasize that even when there is no evidence of violence towards children, it is appropriate to completely separate, it is inappropriate to completely separate or compartmentalize a parent's history of domestic violence towards other adults from the best interest inquiry regarding the parent's child. Such compartmentalization conflicts with the statutory view that a history of violent behavior has relevance, especially when committed against the other parent of the child. Both common sense and expert opinion indicate that a parent's act of domestic violence can have adverse effects on a child, even if the child is not the direct object of such violence, and even if the child does not directly witness the violence. You've heard conflicting testimony. I know you have to make a call, Your Honor, in terms of credibility, but the one thing that's run throughout this entire case of all the evidence you've seen is we have multiple incidences of domestic violence being perpetrated by Ms. Paul against my client. We have only one incident that she's claiming of him injuring her, besides the one that both parties are, the police are saying.
No, I think CCW is Child Welfare Department in Utah, I think.
It's defensive. And I think that lowers the credibility of it and makes it that we don't need it. We don't need her protective order. We don't want to put them on kind of the equal footing here. We need to call out who's the abuser and who's the one that's failing to protect from the abuser in the past, and he's trying to protect them. I did want to mention, there's some text message I submitted. I think it's Exhibit 5 in my rebuttal, where she says he's a good man. And she apologizes for her behavior. But this is 2024, and it's still happening. Also, I know we have siblings in this case. There's two older siblings that Miss Paul has with Mr. Mr. Paul. And what I did want to let the court...
They entered into an agreement as well, and she was, I believe, going to undertake some was it alcohol counseling or
Yeah, I'm not Mr. Paul's attorney, so I haven't really gotten into that, but I do believe you're
working
correct. Your Honor.
back towards 50-50.
The only point that I wanted to mention is that my client has already contacted Mr. Paul, and they've worked it out so that they will be able to make sure that the siblings have contact, even if my client is the primary custodian, because he can take the kids over to Mr. Paul's.
Mr. Swinard, did she have equal custody of her other two kids?
Yes, it's 50-50. She and Mr. Paul were married for 7 years. They have a good working relationship, good co-parenting relationship.
Okay.
And then my final request, and I just wanted to,
So what do you want me to do?
I want you to enter the protective order that we filed. I want you to deny her protective order. I want you to follow the guardian ad litem's recommendations in terms of parent time, set a review. We come back, we deal with it. We have the other case, which Your Honor holds.
Is part of this kind of a review?
Nope.
Just waiting for more information from
DCFS.
DCFS.
DCFS, yeah, you guys are right.
Have that review to do it. I also think, Your Honor, I'll just put it out there. I'm happy to file the motion if you want to give me time, but there was a stipulation filed. There was a final order submitted that was declined to sign. She's now filed new financials.
Never reduced to a decree.
I just want to make sure that we don't have the immediate refiling of new documents. I would probably, if this court needs me to, file a motion to set aside the stipulation to readdress custody matters, as we have very many
I'm
changes.
not going to tell you how to strategize, but
I just want to give me leave to do so in the event that happens. So that's
I don't think that there's anything stopping you from filing a motion to set aside the stipulation that was reached.
totally fine, Your Honor. I just want
Honestly,
2
I
weeks to
would
do
be
it so that I don't
anticipating it.
have to do it
Yeah.
immediately and that was all. So just 2 weeks leave in case they decide to file tomorrow, the
All right.
final documents. But I think that's where it is. Does the court have any questions for me?
No, none further, except years ago, I think, Mr. McDonald, you were suggesting that we do that in this case. I don't have a guardian ad litem on board in the domestic matter.
My suggestion was to do it in this case, and just, this might be helpful information related to that. My understanding is that the parents are supposed to be getting those assessments done. I think DCFS has given them a deadline of May 27th, but those assessments could get done sooner. But that gives you kind of an idea of where things are.
But there's no, you said you were reluctant to say on the record what the services plan was. I'd be interested in knowing what that was.
So what I'll tell you is that
Yeah.
what DCFS is asking the parents to do is a DV assessment and mental health assessments, and then follow the recommendations. So that's sort of what the plan is going to be. We don't know what those recommendations are because the assessments haven't
We
been
know
done
how
yet.
far along they are in that process, so when we get those assessment reports back.
So again, the first step is having the assessments done, and DCFS has given them a deadline of May 27th.
May 27th. It's a while out.
They could get them sooner. That's sort of DCFS's, at least from my conversations with the caseworker,
All right.
that's what's supposed to happen. And if it doesn't happen, then I assume DCFS can't always file juvenile court petition.
Okay. All right. All right. Anything else before I go to Mr. Swiniger?
That's it, Your Honor. Thank you.
Okay.
Only one point on the protective order, Your Honor, because it's been requested by counsel that a protective order is entered against Taylor, not Dakota, because Dakota doesn't need one against him. I do feel, again, setting aside all the domestic violence claims that my client has made against Mr. Mortensen and going to that question of need, does she really need a protective order from him? Does he need to have one entered against him? If we just look at this cycle and how long it's been followed by these parties over and over again, falling into old routines, bad patterns from both of them, frankly, there certainly is a risk that if he's not ordered to stay away from my client and not communicate with her, if there is not a protective order in place, there's certainly a risk that he's going to fall back to his old ways. So that is, among other reasons, why a protective order should enter.
All right.
On custody, I'm happy to address that now if you'd like, Your Honor. On custody, you asked, what's the vision for this case from here? Depending on how we handle it, we could either get some resolution, some movement, and restoration of custody, or we could just go into an infinite review hearing death spiral, which I don't know if anyone's particularly interested in. It has been very difficult for my client to come up with words to describe how she's been affected by being cut off from ever over the last 6 weeks. And for the first 3 weeks, it was completely cut off. And then the court somewhat relaxed it beginning on April 7th. Again, that's at Dakota's request, the initial suspension. As the court already knows, this has been a huge break from the status quo that they've been following since Ever's birth. She shares custody of Ever's 2 other children, which the court has already...
Not Evers, Mr. Paul.
Yeah, that's correct. She shares custody of Ever's 2 older siblings. Taylor and the 3 kids are accustomed to sharing a bunch of time together, and that's been taken away from them almost entirely. In our declaration that was submitted yesterday...
How far apart in age is Ever from the elder
They're
children?
close. 8 and 5.
Okay.
So they're pretty close. They're bunched in together.
8,
They
5,
like
and
to
2.
spend time together. Most of our declaration that we submitted yesterday was devoted to this normalization of custody of Ever. He is a happy and healthy kid. Hope he can stay that way. Obviously, there's some things we need to address here. My client pointed out in her declaration yesterday that she makes it a huge priority in her home to keep these kids off of screens, doing interesting things like art, playing outside, visiting fun places together as a family. It's been remarked by Tara Almond as well as Aspen May, the supervisors in the case, that Taylor shows a lot of patience with the kids. Her harshest form of
This is part of the reason why I was asking, why, maybe you should consider whether we should have had a paid supervision service observing, so I could get a report from.
Yeah, we've got
somebody from
nothing over the
Juarez
last 3
who
weeks.
were
How do we
Yeah.
know any of this
or
is true?
friends Or family members who were conducting the supervision, whose declarations, they're kind of
Such a mistake for her. Such a mistake.
inherently biased, as opposed to somebody from the outside. That might have been a little bit helpful for me as well, as in terms of how the kids were responding when mom showed up.
Sure. I understand the concern, Your Honor, but bear in mind that multiple possible supervisors were suggested, 2 were vetted and selected, and the part of the reason they were selected is because these supervisors, Ms. Almond and Ms. May, they have a great relationship with Dakota and Taylor. And I understand that on paper they're more aligned with her, with Taylor, but these are not
I think they
necessarily.
probably would have been more focused on their mom, but okay, the kids, yeah. All right. It turned out the way it did, and I wasn't going to
Understood.
force it. So.
Okay. So my client, she has the time, she has the network sufficient to continue caring forever. Her friends, her family members live here. Paid nannies live here. Dakota, we don't have a great sense of his availability to really be the full-time parent in this particular case, whether he's overly reliant on third parties. We know that he runs a small business. He rents a room in a home with a roommate named Crew, who apparently is here today.
Can I ask one more question too? Where going back to the parent time issue, this is what's more weighing on me right now. Is you had mentioned I was really more concerned about what your client had gone through as part of her criminal probation in terms of classes, courses, etc.
It didn't work. Whatever she did didn't work.
And whether or not some of that might be, you said she hasn't been drinking at all. I mean, has she been taking random UAs, that sort of thing? Okay.
So that's something that she did on the criminal side, and as Mr. McDonald has reported to the court, that's part of the services that DCFS is presiding over right now. Both parents have been asked and are willingly going to participate in a domestic violence assessment as well as a mental health evaluation. As far as the custody case, the court already understands and has pointed out the strangeness of the fact that Dakota agreed to give my client custody only in August of last year. And I do have to correct the record. It is not a 50-50 agreement. It is approximately 70-30 agreement.
That's right.
In my client's favor. So they followed this from the date it was signed. There were some exceptions for travel and work schedules. He never asked for supervision in the custody matter. By signing the agreement, it's obviously important for a variety of reasons. He gave custody of this child to Taylor only a few months ago. And I think that implies that he understands that she has skills, parental skills, parental fitness, and a very important bond with Ever. And he has an important bond. Ever has an important bond with Taylor. Sufficient to justify giving her custody of this young child. So at the time he signed this, at the time Dakota signed the stipulation, he had a laundry list of problems with my client. In fact, the vast majority of the baggage of their relationship had accrued up to August 22nd, 2025.
This is pertinent to parent time now?
I think so, because again, it does go to what's going on in his head. And so I'll get to my point right now, Your Honor. If he thought, this goes to the question of where is Taylor's anger directed? If Dakota thought that Taylor's anger could be directed at the children, if Dakota's not present, specifically Ever, if Dakota's not present, he would not have signed this agreement giving her custody of Ever.
Let me ask Mr. Paul, just for 1 second here. You made reference to, I think, CCW
That's correct.
guidelines.
That's
Can you elaborate on that a little
Court of
bit?
Appeals, State of Utah,
In Ray CCW.
in Ray CCW 2019, our Court of Appeals.
Okay. And that was in the context of
It's a case.
compartmentalization, when we're talking about violence towards.
Anti-compartmentalization. that
Anti-
We should
yeah.
not compartmentalize. That's the ruling from our Court of
You have
Appeals.
It's a case in Ray CCW. It was a 2019 case.
Oh, we don't want to see these people. I'm sure they're a great news team.
What are they doing?
Telling us about the news team in Utah.
Should we switch
I mean,
feeds?
No, I'll remove it. I mean, we can. I'll remove it.
What about East Idaho
But it's
News?
still playing in our ears, right?
I don't hear anything.
You don't hear the music?
No.
Sheesh. My God, it's so loud in my ears. It's like the music playing, the music bed playing underneath this video of
Oh,
Utah.
okay. Everybody has the same feed. I see. Now I can hear it.
Better be right back. Oh, look at this person. Ooh. What a beautiful. Come on, ABC4 Utah. Go. Get together. Back to the case.
Maybe you turn it down a little.
That's what I'm trying to.
Okay, there you go.
It's not muted for me. Okay, can you hear it now?
Yes.
Can you hear it now?
No, it's still live on TMZ. Yeah, there you go. You got to switch. You got to switch feeds, Steve.
And I need the link.
Okay.
Oh, wait.
Can't you just Google it?
Well, can you? I mean, if you're looking at it, did someone send you the link to TMZ?
No, I'm just looking. I'm just reading the chat.
I don't understand why I'm still hearing it in my ear. Oh, hold on. Boom. Okay, finally. Jeez, it's out of my ear. All right. Okay, I can use another feed. Yeah. East Idaho News has it on still. Just send me.
No, East Idaho News, it looked like to me, is broadcasting the same thing.
They're broadcasting that. We'll be right back.
Yeah.
All right, it's back. It's back. Here we go.
You got to turn it back on for us. Sound.
I don't know if the
There we go.
relationship's dead and gone forever.
If the court
Part of
enters,
that's part of what my thought process is.
Sure.
See, the judge doesn't think they're ever going to.
well, we anticipate a protective order being
course
issued
not.
today, which will be the final nail in the coffin. Obviously, we hope that there will be a co-parenting relationship that can form and
Well, I agree with that.
improve.
Yeah, yeah. I mean,
Um,
that has to happen. I mean,
yeah.
I'll have some things to say about that too.
A couple of just updates from our perspective regarding DCFS, then I'm done, Your Honor. Both parties are engaged in voluntary services. The next meeting that my client has with the caseworker, Hiram, is tomorrow. The safety plan is being implemented. I don't know any details beyond what Mr. McDonald has already said. I expect those shortly. And so my office,
Didn't the parties receive copies of the safety plan?
I think that's forthcoming. And right now we just have the initial.
They usually sign off on it.
You signed a safety plan? No, my understanding from what Hiram has told me, the caseworker, is that that will be entered into tomorrow.
All
He's
right.
meeting with her tomorrow.
When was the case closure on this? When did the report?
I
come
don't
out?
have the exact date, but CPS closed their case, I would say, I feel like it was shortly after we were here last time, around,
And I never got the written report. All right.
I don't know if they would have, Your Honor, I think that they generally only submit written reports if there's physical abuse that's alleged.
I see. Okay, all right, okay.
Couple more points, Your Honor. Both parties have been asked to do the assessments. Neither has started this. My client, we got from the caseworker today a referral. And so we're going to be reaching out and getting that underway.
Okay.
Also, she already has made, and they have already made some adjustments that are helping the situation. She's trying to take accountability and move on. She has been
In
working.
what way?
She's been working with a therapist. She'll continue to do so.
I don't have anything from the therapist yet.
Any
That's
notes from the therapist?
And is there a DV component to the therapeutic intervention here?
That's my client, Your Honor.
That means no.
It's a big theme in the therapy. They're going over it, talking
Right.
about it.
Okay, all right.
We don't know if Mr. Mortensen is. From the tone of his filings, my guess is he is not undergoing therapy. Very importantly, Your Honor, party communications. So messages between Dakota and Taylor have stopped entirely. She stopped the communications long before he filed the protective order.
Well, there has to be some means of communication. They have a child.
Using a third party right now.
Yeah, okay, good.
Now, one thing you'll have to grapple with today is institution of our family wizard. My client thinks it'd be a good idea. If and when they resume those parenting communications, this might be a situation where we continue to use a third party for the time being and then revert and then switch to our family wizard. I think continuation of using neutral location for exchanges would be helpful. Using third parties to facilitate exchanges will be helpful. This has been voluntary, Your Honor. I mean, her working with DCFS, her accepting feedback from law enforcement in terms of how to get make some adjustments to create some distance from Dakota. These have been voluntary adjustments that she's made. Some people completely disregard what DCFS requests, what input law enforcement might provide. But this is something that she's taking to heart.
Well, everyone says that they'll be in compliance. Time will tell, right?
Yeah, exactly.
That's what I've said on my.
I understand. So at this point, again, we are asking for restoration of that custody arrangement that they agreed to in August.
So she wants.
I'll just close with saying these visits, the back and forth, the abrupt end to these short exchanges with Ever and Taylor are excruciating for both Taylor, Ever, and these two other kiddos,
I just don't have an independent report. I think that's your client reporting to you, right?
as well as the supervisors. But also, I think it's a pretty reasonable assumption to make that a 2-year-old child seeing his custodial parent after 3 weeks absence
I don't
is
know.
going through a lot of confusion right now.
Different kids are different. Some are more resilient, some are more adaptive, but yeah, I understand what you're saying.
Yeah, understood. Thank you.
And I do have to address that speculation counsel made. My client is seeing a therapist.
He is?
He
Okay.
is.
All right. Well, let me go ahead and make some recommendations, but I may defer other portions of this. And I have to be honest, I've struggled far more with the parent time aspect of this than the protective order aspect of it. I think there's been, let me just address first this notion of passage of time and filing later on. The statute's pretty clear about that in the sense of passage of time alone not being a basis for denial of a request for a protective order. And I've seen this come up in multiple cases. And typically when I look at that language and I look at the cases where I've seen requests for entry of orders long after the incident occurred, it would be something in the nature perhaps of the context where there was an incident that led to criminal charges being filed, somebody goes to prison, there's a protective order perhaps out of the criminal case that's in play, and then years later they're being released, and now the request for the protective order comes in because of because now that level of fear comes back to the surface as the perpetrator is being released from prison. I do have some issues when we talk about lapse of time and whether or not it's okay just to say, okay, I'll just hold on to that and use it when I need it. When custody issues may arise, for example, years later, I'll go ahead and make my request for the protective order, knowing that there's this passage of time provision, and use that down the road. And I have a problem with that. But when I thought about it in this case, my part of what I thought was, well, if that was the case, there was a stipulation for equal parent, or excuse me, there was a stipulation for parent time, really, that effectively would have resulted in Taylor having the majority of the time. So if he was going to do that, there was certainly plenty there for him to do it before the stipulation was entered into, meaning that he knew about the incident in 2023, the incident in 2025 had occurred, and then the stipulation came after. And then after that, it's when the protective order was filed. So I don't necessarily think that was a primary motivating factor for him, at least to gain a leg up in a custody dispute, because I think he could have done that a long time before. That's not to say that I don't have some problems with the reasons why this was filed, or that I don't have some concerns about his conduct too. Both counsel referred to it. This has been a very toxic relationship. It's beyond the pale in a lot of ways, the toxicity here. And I've had some thoughts about this, about what's this dynamic that we're seeing here. And I think that what I've seen from the evidence, even post last hearing, some of it was before the last hearing, some of it was after, was in some there seems to be a continuing attraction that they have for each other, whether it's physical, whether it's the thrill of the two of them, being a part of making themselves celebrities. There seems to be this attraction that they continue to have for each other. Each of them have been texting each other, wanting to get together for physical relationship, to continue on with the physical relationship. In some cases, she's invited him over. He said okay. In other cases, he wants to come over, and she lets him in. And the problem is that the two of them can't be together in the same place at the same time for very long before it starts to turn violent. And that's part of the problem, that I am very concerned. And I think I just have to say it. This is not anything that I don't say in a lot of other cases, which is that you guys have to figure out a lot here. You have to figure out how to function as co-parents. This has been dysfunctional. This is a lifelong proposition between the two of you. You're going to be, you're linked together for the remainder of your lives. You're going to be the grandparents of the same grandkids someday. You'll be their same graduations, their same weddings. You're modeling right now how you deal with conflict to a 2-year-old. This can affect this child when the child grows up and becomes an adult, and is in his own personal relationships as well. When we talk about cycles, this is part of your legacy. The legacy of violence being passed on from perhaps generation to generation. I don't know. I'm not familiar with your childhoods, but it's certainly concerning all the way around. Meanwhile, I have to make some decisions about, because you couldn't come to agreement as between yourselves, I have to make some decisions about not only entry of orders, but then on top of that, if not here, then in the domestic case as well, about what your parent time arrangement is going to look like, at least for the short term at this moment. I think there's some merit to both of their arguments about their bases for protective orders. I certainly think it's an easier call with respect to Dakota's request for a protective order. The video evidence is really overwhelming. In terms
I agree with him totally.
The elements that go into that give rise to the basis for the entry of a protective order. At the same time, I think there's also evidence, and I'm finding, at least with respect to the May of 2025 incident, that while the bruising, the injuries that Taylor suffered, it's certainly possible that some of these injuries could have been the product of self-defense, but I'm not finding that it's probable. I'm finding that there's been violence that's occurred both ways between these parties. Now, the difference, I think, is that with Taylor, is that her conduct is more reactive. That Dakota knows, and I think that she had indicated this in her paperwork as well, is that he knows how to, and I alluded to it at the first hearing a little bit as well, knows what to do to get under her skin, so to speak, and she reacts. She gives him the reaction that I don't know if he's necessarily looking for it, but she certainly gives the reaction. I'm certainly a little bit. I take some issue with his representations, with Dakota's representations, that his entire motive behind all this was simply to break the violence, the cycle of violence. I think there, first of all, there's a little bit of conflation between when the parties refer to the cycle. Certainly, there's been a recurrence of incidences between this party, but it's not necessarily. Maybe in some respects it is when we're talking about the cycle of domestic violence. All right, an incident occurs, then there's sorrow, apologetic, promises to make changes. Then there's this honeymoon period, where they're trying to work things out. Then the tension builds again. There's another incident, and then it's all happens again. I'm just not necessarily persuaded that all of this had to do with child protection. I think some of it was, but I'm not sure that all of it was, because when I reviewed some of these videos that were taken by him, and quite frankly, this is I haven't really seen a case where the video evidence was of such a degree that I'm seeing in this case, where there's this where it's handheld type video that during the incident, as opposed to say a ring camera that might have been in the room that's recording everything that's going on at all times, where we could maybe go back and look at the whole thing. This is handheld stuff. So he's got this child, for example, in the May 2025, the earlier part of that, I believe it was May of 2025, where he's holding the child in his arms, she's attacking him. I didn't view the video as him trying to leave and get the child out of there. I viewed him as him standing there being more interested in whether there's video recording. He's looking into the camera in some instances, I think in a couple of these videos. One where I think somebody else was filming him while he's sitting in a truck and he's on the phone with Taylor. And so I think part of that is, a greater concern about preservation of evidence than it was about removing the child from the situation, which I think is borne out by the fact that he was supported as well by the DCFS for failure to protect.
Yeah.
So that's so as far as Taylor goes, I mean, I think the nature of her conduct is really reactive, and the kind of this inability to control emotions. I think his conduct really is more, I don't know, how shall we say, give me 1 second here.
What is he reading? His own notes?
Maybe a live transcript of the hearing.
I think it's more deliberative. I think in the sense of subtle, maybe is one way to put it. I think that there is some manipulation. I do think that there is some obsession. I think there may be obsession that they may have with each other as well. But certainly I have some issues when I see the photographs of the evidence that he asserts it's more probable occurred through was the result of self-defense. I don't feel that's necessarily the case. I think it's more probable that he caused these injuries to Taylor, and I do think she's met her burden as well. And I do think it's important that there be mutual orders as well. They need to stay away from each other. Part of my concerns and my thought process as I go through this is I'm wary when it comes to the supervision aspect of it, although I'm not going to make a decision on that right now, that if I'm continuing to supervise Taylor's parent time, I'm wary that that Dakota may actually try to use that as a way to manipulate and control her. I think, I'm just not persuaded either that with Taylor's filing, that it was solely due to breaking the cycle of ending the relationship. I mean, I think there's some merit that I'm giving to the declaration of Jesse Draper as well. At the same time, I don't think there's an extreme power imbalance between the two of them. I don't think necessarily that Dakota was exercising some kind of necessarily like blackmail, because there's several references where she was inviting him over to her home as well. She shouldn't have been inviting him over. He shouldn't have been going over. I am just concerned that if I don't order both of them to stay away from each other, that there's going to be some additional problems that aren't contemplated that may not be contemplated. I don't know what to say in terms of what happens when there's mutual protective orders and they find themselves at the same restaurant or at the same bar or whatever the case may be, hopefully not bars at this point. And you're both potentially being subjected to criminal charges if there's a violation of these protective orders.
I agree with this.
I'm hoping that you're not people who just thrive on the drama and the conflict.
Yep, they are. That's the problem.
Put your child first.
And they haven't put their
and
child first.
Shield the child from this conflict. All right. So my recommendation is going to be mutual protective orders.
I think that's the right call.
I want there to be 100-foot stay away for each of their orders. I'm going to leave the current order in place. I need to think a little bit more about.
That's also the right call.
Lifting the supervision. I have mixed feelings about it. On the one hand, I do have some concerns that if Taylor is in a stressful situation, she has not demonstrated an ability to control her emotions. But as I also said, that seems to have only happened when she's been in the same vicinity with Dakota.
Yeah.
And like I said, I'm wary about the supervision aspect. The court, I guess I should say this, the court would have the regardless of what either party may want, the court would have the ability to lift the supervision at any time. I do think there may be some benefit in waiting to see what's coming out of the assessments.
Yes.
Ordered from the safety plan. I think there's some benefit there, but I'm also contemplating additional time as well. What I meant to say earlier, the word I was looking for is I felt that Dakota's behavior was a little bit more calculating rather than reactive. All right, so I'm going to take under advisement the issue of parent time. Interestingly, over the next week, I'll be in DC at a domestic violence training while I'll be processing all this. So I'll have a written recommendation for you by no later, I'm hoping, than the 11th of May at the latest. Any questions about the PO? In terms of the PO? So same parent time,
Stephanie, I agree.
same parent time as we have up to today, but I'm going to make a recommendation about that parent time on or before May 11th. I may make changes at that time, and then if that happens, will issue a modified protective order that reflects the new parent time order. Right? That's a good idea.
I didn't hear that.
Review hearing.
Oh, yeah.
No, I want to put it on a special setting. I'm just wondering how much time do we think we need?
In my opinion.
You asked for it.
I know. I frankly don't think we're gonna need a ton of time. I mean, what I want to do is get those
Don't want to
assessments.
put it on my regular protective order calendar where I have 15 other matters.
I think
Sure.
that's a good idea, Your Honor, to put it on that calendar.
I mean, depending on how much time you have, I think if we set it for an hour, I think we would be done in an hour. And we might be done in less time than that.
30 days? I mean, are we, or do we need more time than that?
I mean, do we want to have the assessments back?
I don't know.
I would like to have the assessments back. But I'm good coming back in 30 days
When
and
is she,
seeing where
when
we're
are you
at.
going in to take your assessment?
I mean, we're going to do it ASAP. I mean, we have the referral for it.
Let me ask the counsel for the parties.
DCFS hasn't given my client a referral for the assessment yet, but he's been in contact with them and they've been chatting. He's done everything they've asked, so I can make sure we push it up and make sure they get that referral. I would estimate, just based on my knowledge of DCFS cases, Your Honor, and how they go, I think 5 weeks would be the minimum. For a
Of
result.
course.
And I agree with that. And that pushes us out beyond the team meeting that's scheduled for May 27th.
Early June? And I do want to work with both of you to try to restore this to some sense of normalcy. I really do. I just think right now, you two need to stay away from each other, and there needs to be orders that will, result in consequences if you attempt to try to engage each other. Because I still think you have this attraction to each other, physical or otherwise.
You know why? Because the judge goes on Google and reads the stories about them.
You want at 2 o'clock?
You're going to get sued, Judge Minus. You're going to be subpoenaed, and your wife.
That'd work for me.
Okay, Mr. Swinyer.
Would we perhaps be able to do it via WebEx? I expect to be out of town that week.
If you want to make a request for WebEx, I
Bad
think
idea.
you're right. The way I read the rule is that we're supposed to grant those requests unless there's a real compelling reason, like you're going to take somebody into custody.
No, then we can make the first work. And obviously the court is evaluating different scenarios for the
Yeah,
next
and
5 weeks.
And I want to read the case too that Mr. Hall had alluded to, because I think the suggestion there was it's oversimplification to if I'm making a ruling. I don't want to run afoul of the statute, or excuse me, of the case law. If I'm unduly compartmentalizing, saying everything will be fine as long as she's not around him, right?
That's
I mean,
what the case says. You can have my copy if you'd like.
Okay.
What time on the first?
I had
2
2
o'clock.
2 o'clock.
2 o'clock.
WebEx is permitted.
Do you want to do it by WebEx, everybody?
I think it's been a
Make it a
long
remote.
day and I'd probably want to talk to my client about it, but I love the option.
Okay. All right. So next 10 days or so, I should have the recommendation on parent time. At the very least, I'm inclined to expand parent time. The bigger question for me is, should I be lifting parent time? I think you want to go all the way back to the terms of the agreement. I think I'm kind of more inclined to take baby steps towards getting there.
Makes
But,
sense.
That's, I think, a lot, but I don't have really a petition to set aside the stipulation. You were talking about that too. So I don't know really what the objective is otherwise, other than what they had stipulated to before. If that motion's filed, that might change. There may be different objectives there, but where they've already reached an agreement, typically when I'm restricting parent time, I'm working back, trying to work back to where they were before, unless there's ordinarily a petition to modify. Yeah.
That was why I mentioned it, Your Honor, is that I'm more than happy to mediate and work through something and not just file a motion to set aside.
Please do.
Yeah, what I don't want to have happen is within the next, few days, and I'll happy to discuss it with Mr. Sweeney, just final documents filed and I have to rush one in, that's all.
Okay, all right, all right. Well, I certainly encourage the parties to the extent that they can, let's check the box for mediation for sure. Because I do want them to keep working on trying to resolve these disputes. Ultimately, it's the hope of the court is that's the place where you get. So you're not dealing with judicial intervention. You're not coming here, giving up all your power and having the court force orders on the two of you that with the assistance of counsel, you're working out these disputes between yourselves. That's my hope. I mean, unfortunately, you've been unable to do that thus far.
If we can find a mediator between now and June 1st, will the court order us into mediation? We can give it a shot there.
Do I need to order it if you're?
You don't need to order it on our part, and I believe our protective orders will have an out for mediation, if I'm not mistaken.
It'll have a
Protective order
box
should-
checked for mediation. They'll
We're
allow
so
it
just
for
asking
mediation.
if council would stipulate to an early mediation.
Okay, all right. If you're both okay with mediating and working on it outside of court, that's something I'm typically always encouraging. I know there's some DV aspects in terms of, I'm not going to force mediation in a protective order case. Let's put
Most
it that way.
mediations now are online in separate rooms and they never see each other.
Right, right. I mean, if we didn't have Mr. McDonald on the case, this might have been a good one for referral into the new pilot program. But that's presently, that's going to screen it out presently. Okay. All right, we'll come back and have a review hearing then on June 1st at 2 o'clock. But before then, you'll get a recommendation from you in writing about parent. Let me look at it.
It does create, I don't want to speak for Mr. Swineyard, but it does create a little bit of a, yes, chore for attorneys to figure out the parent time schedule week to week.
Indeed, yep.
Week to week.
We've been doing it week to week.
Let me take a look here.
The 8 hours.
Adding to the difficulty is having to coordinate with supervisors. So hopefully, if and when that's lifted,
Well,
it
the
will simplify.
supervisors are kind of aligned with her, are they? Are they making themselves available?
Yes.
They have their own lives
It's,
too.
still a challenge though.
How many do we have?
2 currently.
2. Did you want to expand that? Is that what we were talking about?
We can attempt to. I mean, we would need to speak with our client and go through the previous system of sending them through Mr. McDonald. We're happy to do that.
I hate mentioning professional agency, but I believe there's some professional agencies that can at least coordinate. Or we could use.
Her lawyers are so dumb. I'll explain it later.
That we don't have a third-party intermediary for communicating, or they just did that on their own?
No, we've been doing it through counsel, which is not
Counsel.
sustainable.
I don't think that's a role you want to play necessarily, is it?
I wasn't going to say it, but yes.
Well, I'm okay if the supervisors want, I mean, if you're arranging through parent time, arranging supervised parent time at least, that's going to have to be at a time that's where the supervisor's available. Can the supervisor act as the third party intermediator for making parent time arrangements?
We could, but when we have affidavits filed in cases against my client, it adds to that bias.
It does,
So if we
doesn't
could have someone.
Parents of each of them? Are they hostile towards each other as well? The two sets of grandparents?
I don't believe so.
What I can do is I can submit names no later than tomorrow, and maybe council could do the same, submit 2 or 3 names, and I think this is something we'd be able to sort out because you're asking not for a supervisor, but someone to coordinate parent time.
Well, as opposed to the
Right.
opposed to the council.
Right, just make sure I understand the role.
Yeah.
We could submit names as well. We might need until Monday, but
All right.
You going to be able to work that out without me having to make
I think so.
that decision as well?
Well, one easy way, Your Honor, is to give Mr. McDonald the final call. If you-
The
I
gap.
would be happy to do that.
Okay, all right, as long as you're going. All right, so, I'm sorry, back to your question. Let's just say is mutually agreed, and if there's no agreement, then to be determined by the guardian ad litem. But again, this could all change in the next couple of weeks. I am contemplating lifting supervision. I just want you to know. Okay, anything else from council?
Nothing from us, Your Honor.
Okay, wait right here. We'll get the protective orders issued. These are now 3-year orders, just so you're clear. These orders that I'm issuing now are 3-year orders. They're designed to expire on their own after 3 years. They're not criminal orders. That doesn't result in a criminal record. It does go out on a database though. So if there's an incident that occurs, the police show up, they can run and see that there's a protective order in place. Arrests can be made, charges can be filed. First time around, it's a Class A misdemeanor. Subsequent times for violations, 3rd-degree felonies. I'm really intent on trying to keep the two of you away from each other for now. All right, and then later on, as hopefully the dust settles, we can perhaps scale some of that back a bit. I just think that's what's best for your child as well. The two of you not be in the same place at the same time with each other. I mean, all of the evidence seems to suggest that's a bad idea. Mr. Swinyer?
I mean, Mr. Mortensen's other,
Oh,
it's
oh, oh,
Danielle
what-
Diaz.
Oh, yeah.
Joel Kittrell, Kittrell.
So we're going to issue the orders. I want, you can flip a coin if you want. One of you leave first, the other remain behind in the courtroom, and until one is able to leave the premises, and then the other. can
My
go.
client volunteers to go second.
All right. You do? Okay. Bailiffs have that worked out. All right. Don't leave yet. We've got to get you the order.
And then we'll ask what we'll figure out. Is it okay if I speak right now?
Yes.
So for everybody that's here in the media, I've been advised, courtroom is closed. If there's any interviews that want to be engaged in, we ask, we are required to step outside of the property. Nothing will occur inside the property.
Meaning the broader courthouse.
The courthouse itself. Once you exit the doors, have any interviews.
5:30 in Utah.
But they let them go 8 minutes past.
Yeah. So I could probably get out of this, right? And they're not going to show once they leave the courtroom. Should be good. There's nothing else happening outside of one of them flinging a chair at the other one.
9071.
I don't know who has ever right now.
Like right now, meaning at
I think so.
5:38.
Yeah, I think that's what they're asking. I'll demystify all this in a minute.
Well, they cut off the sound, so you might as well just get out of this, right?
Yeah.
Oh, wait. sound came back on. Yeah, it doesn't look like anything else is happening. So we will get out of this. Let me remove this.
I don't know. Something crazy could happen.
I'll look. I can see it in the queue, but
Okay.
I will. Let me mute it so it's not in my ear. Okay.
If chairs start leaving the ground.
Okay. So basically, from everything that I gathered on this, at just the decision by the judge after 2 hours was, as of right now, the same stipulation is in place. She will look at all the notes that I took.
Okay.
Anyway, same stipulation is in place, 8 hours a week, but in the next 11 days, the judge is going to have a recommendation. He needs to think about it more. He even said he's contemplating lifting supervision, but as of right now, everything that was in place coming into today, that she gets 8 hours a week, stays in place. They've both gotten 3-year protective orders against each other, stay 100 yards away. And he basically said, just, will you two never talk again? Like,
Yeah.
you can't do anything. Like, stay away from each other. You guys are toxic. He said that numerous times during the, referred to it. But that's where we're at. 3-year protective orders for each of them. They have to stay 100 yards away from each other. I'm assuming that means that when child exchanges happen, there's a mediator, somebody in the middle. For right now, as of April 30th, it's still going to be 8 hours a week, but in the next 11 days, because the judge has to go to a domestic violence conference in DC, he's going to come back and he's going to make a recommendation. He said, I'm thinking of adding more time to that 8 hours.
And considering lifting supervision.
And considering lifting supervision. So
Yeah.
I'm still considering it. I don't know. So it looks like she's going to get, at the very least, she's going to get more than 8 hours a week with him.
Which is right.
Yeah. So that's those are the basics. I mean, everything that happened, they talked about for 2 hours. Again, everything that they talked about for 2 hours, like I said, I didn't understand why evidence wasn't being submitted. It was just,
I still don't understand why they didn't have an evidentiary hearing. I'm getting a lot of feedback. Is that just me?
no. Well, you just sound very muffled.
I don't know why.
I mean, I can hear you. It's not like it's light, but now I can't hear you. Now you're muted. Now you have no sound. I mean, if you want to talk, oh wait, here we go. Unmute mic. You see on your name on here, it says your mic is muted. Well, I can't hear you. Do you see this symbol right here next to your name on the screen? It shows that your mic is muted. So you've
Is that better?
Well, now you're not muted, but
Right, but the feedback is still happening, huh?
where are you hearing the feedback? Through your speaker on your desk?
Yeah. All right, let's try this. Yeah, I was hearing it through my headphones, so I took them off, but it was still happening. Yeah, so basically nothing changed. I don't understand why they didn't have an evidentiary hearing. I understand evidence was submitted in advance to the court. That's common. But I don't understand why this was a situation, why they didn't call witnesses and have them cross-examined. I do understand why, Taylor's attorney didn't call her and have her go through the whole story, right? That's very common. That's how we do it in California. You submit your direct examination testimony on the papers. Thank you all. It sounds like it's better. But then you get to cross-examine. So I don't understand that. I also don't understand why the judge kept referring to making a recommendation. Judges make orders, not recommendations. So there's something about the process here because it's in Utah that I don't understand. But I really think the judge clocked them. I think he got it. I'm just surprised he was so much more, provoking somebody and reacting by throwing chairs at people, different issues, right? But I think he clocked the dynamic perfectly. I think clearly it appears that there is provocation here. One thing I will point out is if the genders were reversed here, I think the outcome would have been totally different. I think it's very hard I think if Taylor Frankie Paul was the man and Dakota was a woman, I think the judge would be a lot less concerned about provocation.
Like you're saying, if the video from 2023 was
No,
him
if
chucking
Taylor-
a chair, if
No,
it
if Taylor
him
was a
chucking-
man and the man was chucking the chair.
that's what I meant.
Yeah.
Yeah.
Yeah. And I think that, so I think that because it's a man who's the victim of the chair, chucking and things like that, it's much easier to sort of try to find fault with him and try to downplay the physical violence. Whereas if it's a woman chucking a chair, it's easier to sort of, say, well, he's not really scared of her, with all of that. Yeah, Dakota would be buried under the jail if the roles were reversed. I completely agree with that. If the roles were reversed, and I think that's a really unfortunate thing about how domestic violence is playing out these days. But I don't think the judge was wrong in clocking that dynamic.
Yeah.
I think that is the dynamic here. The issue is, when they said, well, she won't do this unless she's around him. I completely disagree. I think if some, new boyfriend of hers, throws a chair or not throws a chair, but like provokes her, the issue is she has no control over herself, and she's shown that. And, I also found it surprising that the judge didn't give more deference to the guardian ad litem's recommendation.
That's what people in the comments were saying, that they're like, why is he almost combative with the guardian ad litem?
It felt like I felt like the judge was trying to find a way, and it's not necessarily the wrong thing, but I think he was trying to find a way to excuse her behavior and to say they're both equally at fault when that's clearly not the case. I don't believe. It felt like he was really reaching to be able to say a pox on both your houses. And so he was teasing out everything he could deliberately to say they both suck, and I do think they're both wrong. I do think they're both in fault here. They bear fault.
Yeah, it's like the 2023 incident. She was clearly more at fault, but there are other things where, this notion of recording when stuff is going on.
I think that was really unfair of the judge, because everybody knows that domestic violence victims are often not believed. And when you don't have a recording, you're toast. And again, I think if a woman took it out to record it, everyone would say, well, she just wanted to get evidence. But then he takes it out, and it's a manipulative thing on her part.
Yeah,
I think it's very gender coded. And I would feel the same way if the genders were reversed. I would feel that still the woman was provoking him, but that the man's behavior was really bad. I think it's easier here to kind of go the other way. The interesting thing about the failure to protect, that's the other thing that really was interesting to me, was, when DCFS goes in and evaluates, this is
what
common.
Is DCFS again?
Department of Children and Family Services. They call it the same thing in Utah that they do in California. We have the exact same thing. Okay. Child Protective Services is what it's called, CPS somewhere else. They have situations where clearly they've found her to be a risk of some sort. I can't remember what the words were for exactly what the concern about her was, but they cited him for failure to protect. Right? Not for putting the children in danger, but for failing to protect the children from her. And I think that sounds in the grander scheme of things, like it was appropriate, because that to me is a situation where, I think you could accuse this guy of not doing everything possible to protect his children, right? He was clearly playing into this dynamic. He was clearly antagonizing her, it would seem.
Is one of those things, is one of those failures to protect the fact that he didn't report this earlier? Isn't that what he was kind of referring to? Like,
of course,
you had all this stuff and you waited until 3 years after the 2023 incident.
Of course. And that is, that is one of the bases for making a failure to protect allegation. Yeah. That it's, it would be very hard, I think, for any one incident for a parent to be, from just based on my knowledge, you don't see failure to protect in one incident, except perhaps with drunk driving. I have seen it with one incident in a drunk driving scenario where the one parent knew that the other parent was very intoxicated and allowed that parent to drive the children. I've seen that be enough for one incident. But one incident where they don't protect the child that's unusual. It's a pattern. It's when one parent sees a recurring pattern and just doesn't do anything and continues to put the child in potential harm's way by not stopping the cycle. And I think that that's probably an appropriate assessment of what happened here. But then you go back to the fact that, like, again, if the genders were reversed, mom isn't protecting the children from dad enough, dad would be in jail and mom would be hailed as a hero, you know? So it's just difficult, I think, to take the approach that the judge did here. Where it felt a little icky to me that I felt he was trying so hard to reach for them to be equally bad. But at the end of the day, I don't think his conclusion about the dynamic was wrong, and I don't think that his order necessarily at this point is wrong. This is a 2-year-old, and having very limited time with mom is going to be very hard. And I don't think we have compelling evidence at this point that she's an immediate threat to the children, as in, if there isn't, a big, strong man there, she's going to put the children in danger. However, what shocked me the most is this issue of the supervisors, right? Because people often think, if you can get a supervisor who's like on your side, that's great, because then they're going to write all of the reports for you and the recommendations.
Yeah, all the recommendations are going to be like, she was great with the kid. The kid had a blast.
Kid loved her. Kid cried when mom left. Yeah. And by the way, I love that the judge clocked this, because oftentimes judges don't clock this. She should have been the one to want a professional monitor, not him. I understand it's more awkward for the kids. I understand it's not ideal, but she's trying to show that she's not a danger to her children, right? You do not want someone who is obviously aligned with her to be the one writing reports. And it's not worth it to make the kid a little less uncomfortable, I don't think. If you're mom, these people are trained supervisors. Okay. If you get the right ones, they're trained. They don't interfere. It's a little weird, but the kids too. So like the weirdness of it is not something that the kid would clock as much. And I think she should have had, and I was mortified when then at the end, her lawyers didn't say, oh, we need a new supervisor. Let's get a professional one, because it's it's not the right approach for her to be taking.
So the supervisors that have been there when she's had her 8 hours a week are people that she hires on her own, that she happens to know, or could be a family
I think these
friend?
people are known to them. I think these people are known to them and the children. It sounded like that, and that everybody kind of agrees that that they know Ever too. But the argument that like it's a little bit more comfortable to be around somebody who knows the child, to me, mom wants to get the kids back, and I'm sure she feels that it's better for the kids to have more time with her. I think it's probably better for the kids to have more time with her than they have now, right? Forget having someone that they know a little better there. Have somebody who can show the court, hey, I have no dog in this fight. I don't care about anything except accurately reporting what's happening and doing my best for the child whose parenting time is being supervised. And get that person. And then when they write reports saying, oh my gosh, Ever missed his mom so much. She's a wonderful mom. Look at all these things that she did. Then the court is like, oh, well, this person has no dog in the fight. Great. So I just thought that was a big mistake on their part.
So they're coming back June 1st. So they're going to basically have 30 days. June 1st at 2:00 is going to be the review.
I mean, if DCFS can complete an assessment in Utah in 5 weeks, they are the most incredible department of any state government I've ever heard of.
That's not enough time.
In California, we would say like, we'll be back in 6 months, and they probably still wouldn't be done. And it's not their fault. It's really underfunded. They're really overworked. I mean, it is a thankless and tireless position. So I'm not blaming them at all. But oh my gosh, like if they could even report back after a 6-month hearing.
So they're doing a domestic violence and a mental health assessment for each of them.
Correct.
But is that separate from what the supervisor is taking notes when they are there? Like,
the supervisor,
how much do they need? They watch all 8 hours a week, a 1 week assessment of her? Did they have to follow her for like what is considered
So
standard? You said 6 months in California.
No, I'm just saying like, so what I think is happening with DCFS, I think what they're referring to, the domestic violence assessment, I don't think DCFS is really like watching her time with her children this whole time. I think they're doing psychological evaluations, and I think they're trying to determine from assessing them, from speaking to them, from speaking to third parties, what is the real cycle of domestic violence going on in this relationship. But I have to tell you, I think the judge clocked it. I think the judge already knows what the cycle is. The difference to me was that the judge seemed to care much more about the provocation than the guardian ad litem did, right? The guardian ad litem was kind of like, this woman cannot control herself around her children. And she gets in trouble, and I think the fact that this kept happening after it already happened and she had the criminal consequences is very concerning, And the guardian ad litem was more concerned that she's going to be unable to control herself and that she's putting the children in not only an area to witness this, but physical harm. And the judge was more concerned, in my opinion, about trying to suss out who's more at fault for the circumstances between them. And I get that. But to me, that's less relevant to the custody issue.
When I was looking at, I was just like, okay, this, I understood what the judge was saying. And the guardian ad litem obviously is just to protect, is there for his opinion on, and that's an independent person who has no ties to Dakota, no ties to Taylor. It's just
only cares about Ever.
Only cares about Ever. And yeah, when the judge was almost, I don't want to say he was dismissing the guardian ad litem, but
challenging him.
Yeah.
Yeah.
And it was really like, well, why are you challenging him? And I from the outside, I'm like, okay, I'm looking at it again now from a television perspective. What we've heard is season 5 has resumed filming for Secret Lives of Mormon Wives, and neither of them are a part of it.
Oh, is that true? Okay.
Yes, but Taylor Frankie Paul is welcome. Dakota released a statement basically saying, I'm going to step away, but it's almost like they don't want you. Because this show, if they're going to have one of those two come back on the show at some point, we all know it's Taylor. She's way more popular. So it seems like she's going to go back on the show. And they can't go back on the show together because they have to be 100 feet apart. I mean, I guess you could still have Dakota on the shows, but you have to film them. He's going to have to film something completely separate. They will never film anything together.
And you lose the drama.
For 3 years. So, but they will get Taylor back on the show to talk about probably this case and everything that happened and how things are going with Ever and whatnot. But, I don't know. I mean, we got to see how many hours he decides to bump it up to. Maybe he'll double it. Maybe it'll be 16 hours a week. I don't know.
Yeah.
But
look, I clearly they both need intervention, right? But this is not a situation where one person is completely at fault.
Of course not.
It just isn't. It's a horribly toxic dynamic. The issue is, I don't know. I felt like the judge was searching for a reason to excuse her behavior and blame it on him. That was what troubled me the most about the hearing, because I think that is gender coded. Because I think if it were the reverse, I really think there would be jail. And, for the judge to say, he's more calculated, I believe that. I agree with that. But one person is throwing chairs that are hitting children and one person is not.
He said she hasn't demonstrated the ability to control her emotions, but it's when it's around Dakota.
Right. And what if she becomes obsessed with the guy that she chose in The Bachelorette? And what if he tries to break up with her? She's going to throw a chair at him. Like, you better believe it. What if he comes in or what if he turns out to be a jerk too?
Yeah. Well, we don't know she's going to throw a chair at him.
No. Of course not. Of course not. No, but the concern is it doesn't appear from the outside that she has learned to control herself physically from becoming violent when she is provoked. Right? Should he be provoking her? Absolutely not. That's ridiculous.
But she hasn't responded accordingly.
I think the guardian ad litem had it correct, right? And I think that where the direction that they're going in DCFS, it sounds like, where he's being cited for failure to protect, and she's being cited for whatever it is, the danger she's putting them in directly, seems to me to be the right way. He's not innocent, right? He has a failure to protect, right? They don't give those to people that they determine are just victims and don't have an ability to protect the children, right? They don't do that. So I worry.
So why wasn't these last 3 weeks since the last hearing, why wasn't there some sort of report of this is how Taylor has been for the last 3 weeks from somebody?
There was. They submitted declarations. Her side submitted declarations from those two monitors,
but
from the two supervisors.
Those supervisors are pro Taylor.
But the judge was like, why didn't you get an independent person? Like, how good is it for somebody who's in her camp to say Ever loves his mom so much?
And then what was determined going forward with those supervisors? We're keeping the same two. And then they also said something about mediation.
They're going to go to mediation
this next month. Meaning what?
Okay, so mediation is basically a facilitated negotiation, right? The first thing the judge asked when they got into court was like, have you guys worked this out? And that's always the first thing in family court.
And they said no.
Way more so than in civil court, even though we know most civil cases settle. The judges do not want to make a decision. They don't. And I agree with that. I don't think that's wrong that they don't want to make decisions. They would rather the parties make decisions about their lives that they can live with than the judge making a decision.
He said that at the end, like, what?
Yeah.
Don't leave it up
What
to
are you
me.
doing? You know?
Just out yourselves, you know?
And so, and, you know, look, I thought the point he raised was fascinating that, you know, if Dakota was trying to use this as leverage to get more custody, he could have done that a year ago. I don't know what both of their goals are. That's the issue. We don't know. And that's concerning. That's a lot of what DCFS will get into. But yeah, so what they're going to do is they're going to go to a mediation, which is a facilitated negotiation led by a lawyer or a retired judge, where they try to work it out. And usually the way they work in situations like this are one set of people is over here, one set of people is over here, different rooms. And the judge goes back and forth and says, well, Taylor says she wants 80% custody and no visitation. And, what do you want? Okay, well, can we make an agreement?
And then if they come to an agreement, then what happens on June 1st? They present that to Judge Minus, this judge?
Or they call him in advance and tell him we have an agreement. We don't even have to check in.
So there might not be anything on June 1st because they might.
I would find that very unlikely.
That they come to an agreement?
Yes. And that they're going to resolve everything, right? I think it is possible. For instance, I think it's very possible Dakota could say, I'll agree to her having 16 hours a week. I have no problem with that. She can have all day Saturday as far as I'm concerned, but it has to be supervised, right? I could see something like that happening where they have some sort of agreement. But I don't see them agreeing on all the issues. I just don't think that's going to happen.
And look, I don't think anything was settled black and white on all the allegations against each other. And the judge kind of said that in the beginning with, he basically saw holes in both of their stories. So if you're a Taylor Frankie Paul stan and you think she can do no wrong, I'm sorry, but you're wrong in this. That doesn't mean that Dakota is, the greatest guy in the world. No, he's done things wrong too. But this black and white that it's all him or it's all her, you're both wrong. It's not.
I agree. From what I observe,
both of them.
I agree.
Yeah,
it's obviously both of them. It seems like we don't know for sure, obviously, but I think it's one of the things that's getting lost, right, with the criminal charges. You have to prove a case in front of a jury beyond a reasonable doubt.
Yeah, and listening to that today.
I don't think I know beyond a reasonable doubt what happened in any of these incidents except the one that was videotaped, and that's already been the subject of criminal proceedings. I could tell you what I think might have been more likely to happen, but it makes sense that the DA chose not to charge either of them because neither of them are credible.
Yeah.
Right. And when you have a he said, she said, that is such a difficult case to prosecute anyway. even when there isn't like this question as to like who's, the primary physical aggressor. It's just so hard. And so if they have no idea what happened and they don't have a credible victim, forget it. That's it. You're done.
Well, that's what brings me to, I know people were talking about it in the comments, and that's what brings me to the idea of recording. Like, I see both sides, because some people are like, oh my gosh, if you fear for your child so much, Dakota, why don't you be more concerned about getting the hell out of there?
I get that.
Than picking up your phone and recording it. But then the defense of that is, if he does record nothing and we don't have anything from that 2023 incident, and it's just he said, she said, how many more people are going to believe Taylor over him?
Yeah.
Probably way more.
Yeah.
So I see both sides. So I don't know. Where do you stand on recording when there's a giant altercation happening and someone pulls out their phone and records it? Because if nobody recorded anything, nobody would have a concrete opinion, at least with the 2023 video. And looks, people are still saying, well, you didn't see what happened before that video. He locked her in the garage, and that's what it's just like.
Exactly. And to me, the more concerning thing is that it started partway through and then he stopped recording. That's a little weird to me that he stopped.
The 2023 incident?
No. With the one that they were fighting with the kicking. Wasn't there I think there was audio or something because he had his
audio.
Yeah.
And then the May 2025 incident where he had Ever in his arms.
Yes.
And she pushed him. That was the one.
Stopping the recording was what was a little bit weird to me. But I really think it is bad to give a message to victims that if they attempt to get a record that, of their abuse, and if they try to record, it's going to look like, oh, well, I just want evidence. I think that's a really big concern because you are right. It is difficult to believe victims. And I mean, look, what we ended up saying about this May 2020, whatever one was the subject of the criminal stuff already, clearly that was because there was a recording. And we have no resolution on the others because there was no recording. So it's very difficult to say, you shouldn't have.
And so many people who are following this case are just making declarations when they've seen nothing outside of the 2023 video. And it basically that comes down to who you like more, because people are still defending her.
And preconceived notions. Look, I have, I think, a preconceived bias, which is that I think that domestic violence has gone a little too far. And I think that it's very gender coded. So I think that even I go into it with that preconceived bias, and so it's very easy to find things, but that shows you how hard it is to sort these things out. And to me, the right way to look at the recording is if there wasn't a recording and the explanation was I was holding my child, I needed to get out of there, and the evidence was consistent with that, then I would basically give no weight to the fact that there was no recording. But it's really hard for me to take someone down a notch in terms of their credibility and believability because they recorded it. For me, that's really hard.
And that 2025 incident where he's holding the kid, there is video of that. It just hasn't been made public. The judge saw it. He talked about it. And
I think he said, though, that because the phone was in his pocket, though, isn't it?
Yeah.
So it was audio.
It was
but
audio.
That's what we tell victims. That's what I tell victims of people that are victims of domestic violence that are not that aren't able to call the police because they have a bloody nose. I say you need to come in with a recording. Now it doesn't mean you can't put on a case without that, and it depends on what other evidence you have. But that's the big advice: is when something starts, hit record.
Yeah, the bloody nose thing with her. I mean, again,
the
judge said you have a picture of you with bruises on your arm. You had enough time to take bruises over your arm, but you didn't have time to take a picture of your bloody nose.
I mean, whew.
Yeah,
that's bad.
Like, why wouldn't you take a picture of that?
Right. And so I don't know, it's difficult. I think the fault lies in both corners from what I have seen. And my big takeaways, I thought the judge was too dismissive of the difference between the danger posed by one versus the danger posed by the other. But also, look, he also didn't say, when you look at the outcome, no, I don't think anything wrong has been decided yet. It's not like the judge said, Oh, well, so I'm going to go back to 80-20 today. That would have been alarming to me.
Or 7.
And I know there were some people who were predicting that would happen. That would have been outrageous to me if he had said, yeah, they're going back to Taylor's, like, get out of here. You're a manipulator. So even though he had so much trouble with her, they're still in Dakota's custody. So anyway.
She gets 8 hours, but in the next 11 days, we'll find out.
I mean, that's nothing. 8 hours a week with your children is nothing.
Yeah. But we're going to find out. I'm guessing it'll go up to 14 or 16 hours. He's going to give her more hours, and he said, I'm still contemplating removing the
whether
supervisor.
It needs to be supervised.
Yeah.
Yeah, that.
And then and then he did say the reason I'm worried about that is because she's going to use it against Dakota. Didn't he say?
No. So this was another thing that I felt like was really concerning to me. He said that he felt like the judge felt like Dakota would abuse the fact that he had primary custody and use it to control and manipulate her. It's like, but you're giving her a protective order against him.
Yeah,
so how is he going to do that?
How's he going to abuse it when he can't have any contact with her?
That might be a reason to make the protective order go both ways. And I'm glad to hear that Utah also has a preference against mutual protective orders, because it does actually harm victims long-term to just throw out mutual protective orders, because then people that are victims end up with a protective order against them. And that creates all sorts of problems, as we learned from Mike, and things like that. But
when he talked about parent communication, he mentioned Our Family Wizard.
Yes.
Is that third-party app where the only way they talk to each other is through an app that everybody can, that it's not like Dakota texts Taylor on his phone, she texts him back.
That's correct. You have to log into an app.
Log into an app to text her.
And the guardian ad litem would probably have an account forever and see all the communications. They have a shared calendar. And the court has access directly to the communications. A lot of people think that means that the judge is like watching as you email the other party. It is not. They just have a way to verify the accuracy of the records, right? When it's done through Our Family Wizard. It's an evidentiary plus.
Which is something that I'm just shocked hasn't happened until now. Like, I just thought once, I don't know, maybe going back to February, like, these two don't need to be texting each other anymore. They should not have communication unless a court can look at their communication, because then it gets into what if he deletes them.
But that's kind of the thing, right? Yeah. I mean, but it's not like the court is sitting there looking at it and saying, wait a minute, they're going over to each other's houses. Like, let's stop. It's not like that. So, and I get it that, Our Family Wizard is expensive. And it's a little bit of a pain. So there's a good reason not to just implement it in every single case, but it should absolutely be used.
These two need it.
What's that? Oh, absolutely. In this case, you should use it. Yeah. 1,000%.
I think one of the things that the judge was also worried about was, how do we know? I mean, after all of this and his accusations about what she did to him in the car and her pushing him when he had Ever in his hands, and, this obsession that she claims that he has with her, which they do. They have an obsession to each other. Again, it's not a one-way street. It's not like, oh my God, Steve, you're crazy. He's absolutely obsessed with her. She's obsessed with him too, because she takes all of his advances and he continues to give advances to her. They're both ridiculous in that aspect.
1,000%.
But what is interesting to me is this whole notion of, well, if the obsession is going both ways, I think, again, like you said, what if a new guy gets brought into this? Doug, for example. We're hearing that they're possibly trying to rekindle something.
Oh, that's the guy from The Bachelorette.
Guy from The Bachelorette that she picked and then cheated on the day she got back from filming, and now apparently is starting to rekindle. First off, if Doug wants to get back with her,
good riddance.
She's not in a position to be in a relationship right now. She needs to not be with anybody.
Yeah, absolutely.
Anytime soon. Just don't date. You can not date, Taylor. It's okay.
Yeah. And by the way, when he said, like, oh, are you doing domestic violence counseling? And he went back and he was like, oh yeah, that's a big focus. That means no. She's not in domestic violence counseling. And therapy, when you don't have a record from the therapist, therapy is self-reported. We have, there's nobody reporting on this. She's going in to a therapist that she's hired to work for her. right? She could be, for all I know, she could be talking all day long about how hard it is to be a victim of somebody else and do nothing wrong. That's what she was posting online, you know? So
So in these next 4 weeks, though, she's got to go through that. Both of them are going through DV and mental health assessment. Right?
Assessments, yes.
Assessments, right. Which is what is, I mean, I know I would assume I know what a mental health assessment is, but what is a DV assessment that they're going to go through? What is they going to be?
It's psychological testing.
Okay.
Definitely. It's speaking with them both. It's talking to third parties. I mean, I assume it's just more part of this. I don't know exactly what they mean by that, but I'm pretty sure it's something standard in Utah, right? But they have it's assessments by mental health professionals who are a little bit more qualified to sort out, you know, is this really, I mean, than a judge at least, you know, is this really a situation where he's the real problem and she's really just, you know, she'll never be like this with anybody else. He's just so good at pushing her buttons, which seems unlikely to me, but I don't know, you know? So it's hard to know, but it'll be mental health professionals that are better equipped and have more time, right? Because at the end of the day, the judge, I mean, that was 2 hours, right?
Yeah.
Like, you know, it's hard. It's hard to pick a, you know.
And you wonder after today's 2 hours if, I don't know, they're both sitting there going like, you know what, the judge is right. Can we just not that we need to go bang it out again, these two, but because they clearly have to stay away 100 yards away from each other.
Mm-hmm.
But, and oh, by the way, on that point, even though there is a protective order for each of them to stay 100 yards away from each other for the next 3 years, if they want to privately meet up and go bang it out, they can, right?
No.
As long as the other one doesn't report the other. What if they privately just said, I'm horny tonight, and these two, like, could it happen?
Of course.
Okay.
Of course. Yeah. And the practical, all I'm saying is legally, that doesn't make it okay. Legally, that would not excuse
them.
But
if both decide to say, let's never say anything to anybody, we're horny tonight. Dakota, I miss you. Taylor, I miss you too.
Right.
They could do that and nobody gets in trouble as long as it never gets out.
Of course not. And if a third party calls and reports it to the police, I think they're not going to prosecute a case like that, you know, where there's no complaining victim.
Yeah.
So yeah, of course that could happen as a practical matter.
That's where I think the judge, he said it a few times about this obsession with each other. I brought it up on my podcast a couple of weeks ago. I'm still not convinced that these two are never going to hook up again at some point.
I'm not at all convinced.
Yeah, I'm not. I don't, because as the judge said, you guys, for the rest of your life, you're going to be connected by this child.
Yeah.
You know, and while I am suggesting or putting in the order, you got to stay 100 feet away from each other for the next 3 years. How do we know? Again, I can see these. We've seen 4 seasons of this where these two cannot quit each other on Secret Lives.
But look, that in my opinion is a good reason to have it be mutual, right? Maybe not legally, but practically.
Order be mutual?
Yes, because that way they're both equally culpable and in danger for violating the order, as opposed to a situation. Look, I'm not so sure, which is kind of shocking to me, that she even met her burden to get a protective order under Utah law. I'm not even sure legally that clearly he did. In California, she did meet her burden for sure, because it's such a low bar. But it is a good reason to issue protective orders going both ways, because otherwise only one party would have this huge recourse. And so you'd have one of them who, if he is as manipulative as the judge thinks, would probably induce violations. And then you've got the police involved, and you've got criminal consequences again. And then it goes, you know, so I get that. I don't think the judge was wrong to conclude that that's a really compelling reason to have mutual protective orders.
Did he say they can't text each other?
Yeah.
Call each other?
That's
to be the family wizard thing for going forward.
Well, no, they haven't implemented, I don't think, our family wizard yet. That's why they were talking about communicating through. They were trying to pick a third party to communicate through at the end.
Okay.
Yeah, I don't even think they're even there yet. being able to do it on our Family Wizard. But
So let's just say they don't come to any sort of mediation, any sort of agreement in the next 30 days during mediation. On
Yeah.
June 1st, when we come back to this, which is 2:00 on June 1st, which is a Monday, day after my
Right.
birthday. Yippee. We come back to this on June 1st.
Yeah.
At that point, there should be written assessments on both people from their mental health and TV.
if they do, I am going to issue a public declaration, like praising the efficiency of Utah DCFS. I mean, if they really are done by then, that would be incredible and really impressive in terms of their efficiency. It also might be a little concerning in terms of how quickly it happened, but maybe not. So yeah, that's the idea. They think they need 5 weeks for those reports to be finalized. And so they're going to come in for like a check-in hearing, like a status conference.
And the judge at that point will look at it, look at the assessments for
Yes.
each of them, and then rule.
And then might change custody time.
Might
And
change
this is
custody
part of what he was saying, which I think was really good, the judge. He was saying kind of to Dakota, usually when this kind of situation happens and you have somebody like Taylor Frankie Paul who needs their custody time, there's a goal there. Get her back to 50-50. Get her back to 30% if she only had 30%. There's some sort of like path, right? We call them step-up programs a lot, right? And it's not really even clear what Dakota wants, right? But there has to be something that they're going for because she had 80% custody by agreement up until the beginning of this year.
Started 80-20. Yeah. In June of
Or
last year, it was
70.
80-20. And then in August, it came 70-30 when they're
Okay, there you go. So they're clearly, there has to be, I can't imagine that Dakota's goal is that she's going to have 16 hours for the rest of Ever's childhood. That would be, and if it is, it's a ridiculous goal. And it's one that's not in Ever's best interest if she improves. The goal should be for her to improve and figure out how we're going to get to a particular place. Now, if Dakota came in and said, now I think it's important for it to be 50-50, I actually think that would be very reasonable for him to say, now I think it should
on
be
June 1st for his lawyers to say that.
Oh, for him to file something saying, I think she should work her way up to 50-50 as opposed to back to 70-30. Especially given how toxic it is. I think him wanting equal time with the child makes sense. And that I'm saying that knowing that the preference legally is for 50-50, and I'm leaving out whether I think 50-50 is good for a child. Okay, that has nothing to do with it. But if he felt like that were the right thing, I would give that a lot of weight. I would not think that that was necessarily wrong. But we don't even know. Maybe he thinks he should have full custody. And that's what the judge was kind of like, I don't even know what you want, sir. I don't even know where you're going with this.
Yeah. So when does his lawyers come out and say, talk to my client, this is what Dakota would like, judge, and then the judge rules, yeah, I'll give you that, or no, I don't think that's right.
I mean, I think that's what they're going to submit. I think that they said they're going to submit that soon. But that's also something that will be discussed in June, and I would expect they would express a preference before then. But the idea,
when does Taylor's side say we would like this, the same thing?
Yeah,
they both
absolutely.
Okay.
Yeah, and then the idea in June, presumably, if they have the assessments back, it would be to. I mean, I don't know what the judge plans on doing, and it would depend partially on the assessments. If the assessment says, "Oh no, we've done all the reviews, and he's the only abuser," I don't think it would, but if it could, and she's literally just 100% reactive and innocent, maybe the judge will just completely change custody in June. But if not, June is going to be to say, "Okay, we're going to give her one overnight." Okay. As long as we don't have, and then let's come back in 120 days, or maybe not even let's come back. In 120 days, one overnight will become 2 overnights or 3 overnights. Who knows, right? And Dakota, you come back if something happens.
Okay. Well, I mean, it's far from over. And I think the biggest thing to take from it, if you're joining late here in the process, 3 hours in, essentially nothing changed. She still has 8 hours, but in the next 11 days, the judge will recommend probably more hours. He says I'm leaning towards more hours, and I'm still contemplating whether or not to take away the supervised visit. So maybe Taylor will get Ever for 16 hours a week. She doesn't have to worry about anybody being there. But as of right now, it's the same custody as it was before the day started.
Right.
That's where we're at. So,
Yep.
Good Lord, that was long.
I think it was interesting.
Yeah. I mean, I haven't taken notes on anything. Well, I should say I do when I watch the show, and I have to do my, when I used to write the column or whatever, but
Yeah.
something like this, like to take notes about to do a show. Well, I took notes on the Valley. I have to take notes when I watch the Valley too, but not as detailed as this. Like I'm all over the map here. I can't even sometimes read my own writing here, but I understand.
Yes.
I mean, I think I had a good grasp of what was happening. I just thought, honestly, you asked me whose lawyer was better. I definitely think Dakota's lawyer was better. I didn't think
Much better.
Taylor's lawyer there were times where I didn't think Taylor's lawyer, he almost pulled a Jingers where he wasn't really familiar with everything happening.
Yeah, before my
that
time.
happened in the past.
Yes,
Yeah.
yes. I thought that too. And the only thing that I was more that I thought Dakota's lawyer really missed the boat on, I thought her lawyer's argument that she was taking responsibility was a good one. He should have come out with those posts she was putting on social media. Like you will see, I bear no fault in this at all. And I would say, yeah, her lawyer's telling her to do that in court today, but that's not what she's saying.
Well, the other thing is when you I'm trying to think of, oh crap, I think I just lost my train of thought.
Sorry.
It was, what were you just saying in regards to
That she was taking responsibility.
Yeah, wasn't that
The lawyers, I thought he missed the boat on that. Anyway.
Yeah, and him coming forward and saying, "Wait a second, she's saying she's taking accountability, but
look at her social media
posts suggest otherwise." Yeah, he could have fought back with that, I guess, but he didn't. But yeah, her lawyers just there were some things where he seemed to miss the boat, and he kind of repeated himself a lot. I felt like he wasn't great. But my thing was watching both of them. There was so much time in this case spent to rebutting all what happened in the incidents, and it got nowhere.
Yeah.
Nobody is any more smarter about what happened in these incidents than we were before the day started.
The judge should have just started by saying, "Look, I'm obviously issuing a protective order against her in favor of him," because clearly, even though I thought the judge was kind of going out of his way to help her, clearly the judge had already decided it was obvious
because he kept referring to the 2023 incident, which we have video of.
Right. And he clearly was like, that was not a difficult decision. It's a more difficult decision. And that's obvious. Obviously, it was a harder call with respect to whether he should get one. Now you made me lose my train of thought. But no, we didn't really get much more clarity on what specifically happened.
So basically, they talked about the evidence that they had submitted and the judge had seen.
Yes.
So they just
argued
talked about it. Yeah, they
argued it. There was no testimony. This was not a.
Yeah, we didn't see it up on a video screen and.
Right, and it really wasn't an evidentiary hearing. I understand, like no exhibits were admitted into evidence. I understand there was evidence at the bench that the judge, but those had been pre-admitted. No testimony was taken. That's what surprised me the most, honestly, because you want to figure out who's telling the truth. Put them both on the stand. I give me an hour with each of them, and you'll know who's telling the truth. And it may be neither of them. It may be both of them. Whatever. It's very hard to assess credibility without having a witness on the stand.
Yeah, I didn't understand. Like, don't judges? I feel like you take more notes during hot bench than this judge took. I mean, he's listening, but
yeah.
But then, like, remember when he was at the end when he was giving all of his opinions, he was just looking at a computer the whole time. I'm like, but he wasn't taking notes during the. So what is he reading? Someone taking the notes for him, and he's just making his assessment based on what he's reading and his memory. I just thought, I don't know. I guess
I don't know what he was. Normally, what they're looking at there is what's called live I don't know why I just went blank, but it's live court reporting. It's the court reporter and it's the live transcript.
Okay.
So they're literally able to see as it's happening, what's being said, what's being argued, yeah, I don't know why I'm losing the name for it right now, but it's the live record of what's going on. Yeah.
But he's going through it, looking at it, but also in his mind, like what he remembered from both lawyers presenting what they did. And it was just weird because I never saw the judge write one thing down during. So either maybe he's got a photographic memory. I don't know. Maybe I don't understand like how he.
And that's what surprised me so much. Like with one or two very small exceptions, right? When we do DVs in California, we don't do opening statements almost ever, right? Sometimes it can be very helpful for a lawyer to do a closing argument and to kind of bring some facts together for the judge to argue about the facts, right? And of course, there were a couple of legal arguments, a couple of cases cited, and a couple of good points made, like harassment, I guess in Utah has to be a threat or something like that I heard. That's good. I mean, the judge should know that, but no harm in reminding them. And then there were a couple really good, points, I guess, kind of made by the lawyer. But the judge doesn't need to hear two white guys arguing, about, right? He doesn't need to hear these like 2 40-year-old men saying like, well, but I think that my client would say this is what happened. Well, my client would say this is what. The judge should have just seen them both testify and then decided. That's how you figure it out. It's not like the lawyers arguing about it very much, right? It's the lawyers can synthesize the testimony, and the lawyers can say things like, Your Honor, you heard her argue, you heard her testifying, didn't you notice that she got nervous every time we brought up blah or something? That lawyers can do that, or Your Honor, I want to point out that what she said in minute 2 contradicted what she said in minute 27. That's very helpful. That's why we have lawyers.
So these two are never going to take a stand. It looks like take the stand on anything.
Well, I don't, now that it has been announced that there was going to be no, because I thought about that, right? One of the issues when you have a DV is you don't want the client to testify because of potential criminal responsibility, right? That's always a concern. It's also a reason you don't want the client to submit a written declaration too, though, because that can be used against them also. So people that are really concerned about criminal implications just will not say anything. They will not submit a responsive declaration. They won't testify, right? Clearly, they weren't worried about that here for 2 reasons. Number one, they both submitted lengthy written declarations, more than one, apparently. But number two, there's already been an announcement they're not going to be prosecuted. So why did we
have to go back and forth on 9 incidents that happened and what they thought did and what the other side thought?
That's what I don't get, right? Because I think what would have helped the judge here was to actually hear from both of them and see who appeared more credible, especially when this whole thing apparently hinged on credibility. And yes, if you say something different in response to, in the response to the police versus what you put in a declaration. Oh, okay. One is a lawyer writing it, and one is the police asking specific questions. Like, get them on the stand, observe them testifying. That's what would have solved it for me.
Yeah.
But who knows? So they got to stay off social media.
Well, the judge didn't say that.
No, but oh my God.
Taylor went back on social media today. Well, she turned it back on. She didn't post anything, but she, for a week, she said, she made that statement. I'm going off. I'm going to take time to myself. Or actually, she didn't make a statement. Her social media deactivated. Well,
interesting.
It reactivated today.
Okay.
But she hasn't posted anything. Maybe she will and just be like, maybe she'll now put out a statement saying, I'm going to focus on myself. Her sister posted under somebody else's post about Taylor Frankie Paul has shut off her Instagram. She just said, it's been really hard on all of us. Taylor is just taking a break.
But then shut it right.
But the break lasted a week. The break lasted a week because she turned it back on today. So I don't know what she's going to do.
They need help.
Both of them.
Both of them.
The judge knows it. The judge said this is a toxic relationship. You guys need to stay away from each other. He said that. Stay away from each other. Can they? a different story. And this whole thing, if this story is true about her wanting to rekindle with Doug and they're trying to work stuff out, it's just a bad idea. If you're Doug, why would you want to get involved with somebody who's just dealing with all this right now? Her headspace isn't into dating right now.
No,
Now, maybe he just wants to hook up. Maybe that's what it is. He just
I mean, that's the answer,
It's
right?
got to be it. It's got to be it. There's no way he could be seriously like, yes, I want to dive into this relationship. First off, it's also long distance because Doug is still in San Diego.
Did they get engaged?
Yeah, and she cheated on him with Dakota the second she got back from filming. So,
But they did get engaged.
yeah, they got engaged and she broke it off. But now they're rekindling or trying to work on things. It's just like, Taylor, it's okay to not have a boyfriend and not try and work on things with
For
somebody.
5 minutes.
Yeah.
For 5 minutes.
We're just saying, get through this stuff. Get through your DV assessment. Get through your mental health assessment. Work on
Get
this
custody
part.
of your child back.
Yeah. She has no business dating anybody right now. It's her life. She can do whatever she wants, but I think that's a logical statement to make. Maybe work on yourself first before you get involved with anybody, not just Doug, anybody.
And I think any therapist would recommend that, right?
You'd
You know,
think.
like this is not the right time to enter into a new relationship.
Yeah.
You know, it's not healthy.
All right. I'm going to probably use this audio
Oh, Lord.
just from when from the court ending, because you can watch the audio.
Oh, yeah. Yeah.
You watch the YouTube video, but I think for my daily roundup tomorrow, it's just going to be from the time we shut off the court case and just talked about our thoughts on this. So it's probably like 40, 50 minutes. I'll just use that as my daily roundup tomorrow. Cause we'll see. I don't know. Maybe I won't. I haven't decided. Got some sports to watch and then I'll figure it out. All right. Thank you, Rachel. I really appreciate it. All you that were in here. Thank you so much. 1,500 people watching on this.
Oh, awesome.
Big day. Thank you all for coming in. I really appreciate it. And we will see going forward what happens. I'll keep you updated on my daily roundup, and hopefully, I mean, we'll be able to see when the judge makes this recommendation in the next 11 days once he's back from this DV conference in Washington D.C. Will that be on a docket? Will we see what the new thing is?
It should be. I'm just confused about this concept that the judge is making a recommendation. Some Utah attorney will have to explain that to me. I'm sure there's a very easy explanation for it.
It could be the wording. If he says 16 hours, no supervision, that could just be an order, but they're calling it a recommendation, which seems weird because why wouldn't you just call it an order?
And judges, I mean, of all people, right? We know that we have power, right? No, but I mean, judges don't usually say well, I'm going to make a suggestion. They say I get to decide. That's what you are when you're a judge.
All right. Final question. Who's a better judge, Judge Russell Minus or Judge Julie Mata?
Oh, come on. I don't know. I have no idea. I have no idea.
You've seen them both perform during a 2-hour hearing. Who's better? Did you like
Judge
Mata or Mata better?
Judge Mata was listening. Judge Mata was not. She didn't deliver her ruling orally, right?
She didn't have to deliver it right away.
There was very little that she did. She listened.
Or 8 days.
Took evidence and then made her ruling later on. So there just wasn't a lot to see from what I saw. There just wasn't a lot to see from her.
Yeah, she didn't talk and ask questions like Judge Minus did. Yeah.
Yeah, he made a lot of really good points. I was just concerned that it felt like he was, from the very beginning, determined to kind of tease out what he needed to say it's just as much his fault as her fault. And that to me is, I mean, that's the one thing as a judge, you're not supposed to do. You're not there to cross-examine people. You're not there to make the facts fit one particular version of events.
Yeah.
You're there to figure out what happened.
And two completely different cases, what Julie Mata was dealing with versus
totally different.
Judge
Totally
Minus
different. Yeah. And there's a kid involved in this case, a real one.
Yeah.
Imagine that.
Don't you dare say that about Laura's 2 unborn blowjob babies. Don't you dare.
I didn't say anything about her.
Oh, that's right. That's right. Yeah, Laura, she said nothing. I know you're listening.
I said nothing.
Yeah. All right. Thank you, Rachel. Appreciate it. Thank you all.
You got it. Bye, guys.
And we're done. Talk to you tomorrow. See ya.